Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcake's sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, good morning, good afternoon, good evening, depending on where you are. For me, it's morning, and we're going to try this again today. Got an Ethernet adapter because I forgot to bring mine with me, and we plugged it into the Ethernet, so hopefully it's going to work better today. If it doesn't, that's it. I'm just going to pull the plug, and we're going to just reconvene tomorrow night when I'm back in my usual location, and we can do this the way I like to do it, because I hate to do it when it's not right or perfect. But can you hear me? Are we good? How's the volume? I adjusted the volume so you could hopefully hear me better and I don't have to shout and disturb everyone else who's sleeping here. How's everyone? Yay, internet. Ethernet. So yesterday I gave you my thoughts for about 20 to 25 minutes before I was so rudely ejected from StreamYard. StreamYard was having big issues yesterday. And it seemed like the Wi-Fi here was not cooperating and, whatever. And then by the time it got all sorted out, I had things to do with my family. So if you know my channel, you know that my family always comes first. So, that's what happened. What happened in the stream yesterday is that I have family and I'm on vacation and, there's an itinerary. And when it didn't work out with the internet and the StreamYard issues, by the time it did work out, I had other things to do. Sorry. Not sorry. My kids are always going to come first, and you know that. Thank you. So I gave you my thoughts and feelings about what I thought happened on Marzi got my Wi-Fi. I think he cut me out. And like my white balance is off. I know I look a little green. I don't know. I'm fine. Please don't worry about my health. I'm completely 100% fine. It's just there's curtains over here that are like brown, and there's a ring light. Listen. I am not a cupcake. But I'm here. So let's talk about it. So we talked about my thoughts and feelings on what happened last week. I thought it was a big, a lot of hyperbole by Brennan. I think he's going to have to prove it, and I think it may backfire on him. So many people have been sending me other people's content to watch. I don't have time to watch somebody's 5-hour and 47-minute stream. I'm really sorry. And you know what? My opinion is not based on what other people's opinions are. If you ask 5 lawyers for 5 opinions, you will get 5 completely different opinions. I think Brennan had a lot of hyperbole in what he had to say. I think a lot of it was misstatements, and I think he's going to be left with egg on his face on Tuesday. I just do. That's how I feel. We'll see if I'm right or if someone else is right or if we're wrong. I know. Can you believe I had a life outside of YouTube? Wendy Sue, Winter. Truth. I know it's hard to be everything to all people. It's hard. If you're a mother and you have kids and you have parents that you're taking care of, and your kids that you're taking care of. This is like, we are the sandwich generation, my friends. Gen X is the sandwich generation. We have parents to take care of and kids to take care of, and it's a lot. It's a lot. But I do have feelings and thoughts, and I want to share them with you. A lot of hyperbole. I know, and there's so much rampant speculation around the internet. How about we just wait and see what happens? How about You know what I also am a big proponent of, and I feel very strongly about this, worry is a wasted emotion. Worry is a wasted emotion. Half the time you're worrying about stuff that already happened. So what's the point? It's done. And the other stuff you're worrying about, the other half of the stuff you're worrying about is stuff that may never happen. So what's the point? I don't know why people are getting all worked up about something that we really don't know the full. Yes, Aussie made a video. Yes, I saw Aussie made a video, and she was kind enough to send me all of her research. And when I have a time, I will do the research. But yes, so I don't know. Anything is possible. Bias Bev, anything is possible. She could have had an ex parte with Marcy. She could be under federal indictment herself. She could have a sick child. She could have a sick husband. I don't know. She could have medical conditions. I don't know. But for me to sit here and us to talk about a million different things that could have happened is kind of pointless because we don't know. But we do know, and that's a great question, Bias Bev, because a lot of people are asking me. Well, we do know because we know the facts, and we know that Hank Brennan misstated a lot of things in court. And I also know one thing that nobody sent me, but I found on my own. I can't up on my timeline. If you haven't watched it, I'm going to link it to the stream. Boozy Beauty did a great video. I think it's on YouTube, right? I don't know if she's here. I don't even know if she watches my channel, but she did a great video with the entire timeline of everything that Brendan was talking about, all the stuff that happened in court. What happened on June 10th, and we spoke about it yesterday. It was Yannetti who was on the record on June 10th. None of the communications that we were provided with happened until after June 22nd, because that was the voir dire, and then after that was the testimony of Arca. And I told you yesterday, as a litigator for 30 years plus, you have to logistically schedule your experts. People just don't show up to court. Clerk Jim does not pick up the phone and say, hello, Dr. Wolf, can you show up to court on such and such a day at such and such a time? And, the court's going to take care of your travel and hotel. It's not the way it works. So there's that. And then it's weird. And then she just ended it abruptly. And we don't know. We don't know what happened. Yeah. So did you see Boozy Beauty? Boozy did a great video. I don't want to play it without her permission, but it's only 10 minutes long. And it sets forth the whole entire timeline. And so, let's see what happens. Are they going to come in with big guns on Tuesday? I think so. We'll look at the order in a second. I do want to address a couple of super chats from yesterday that, after I was so rudely kicked off the internet by StreamYard, I did not get to address. And I always like to thank everyone personally, because my mother always said, make sure you write your thank you notes. And that was back in the day when we wrote actual thank you notes with a real pen and a real stamp, and we actually really sent them in the mail. All right, so Melissa Bestford came in from Australia with a 15 Australian super chat and said, Melanie, hi, Melanie, been waiting to hear from you for what seems like days. Haha. Busting to hear what you have to break down today. And we broke that all down yesterday. I think we don't really need to rehash that unless you guys have any specific questions. But we'll look at the order that there's an order to appear that the judge issued. Today's only Saturday, right? It feels like, I don't know what day it feels like, but it feels like a different day than it is. Mrs. Bouquet came in with a super sticker. K-Wags came in with a 5 and said, Olivia had a good ex. Hank Brennan knew all these things prior to filing, and he left them all out of his motion. Yeah, I think we addressed that a little bit, right? He knew it all. But we've seen him misstate facts, misstate testimony so many times, and he's admitted that he didn't watch the trial. But now he says he read the trial transcript, which I don't know why you could do when you could just listen to it through YouTube. I don't know. Some of the stuff obviously wasn't on YouTube, like the sidebars that had to be transcribed, so we'll see what happens with those. And you can bet your ass that they're going to be in the motion to dismiss, which, as of my last checking of the docket, had not been indexed yet. It hadn't been put into the docket. However, do I think they made it in time for the deadline, which was yesterday? Yes, I absolutely do think the defense made it in time. Do I think that perhaps it wasn't scanned in intentionally? I don't know. You decide. Because then people like me would be talking about it all weekend. And what's going to happen is we're probably going to get a copy of the motion to dismiss on Monday. So Monday will be a big day for us. And then Tuesday we have a hearing at 11 a.m. Eastern, which will be a big day for us. And so we're going to see what happens. Sandy B came in with a 10 and said, I think she wanted to kick AJ off that day. Marcy told her to take a breath and give them a week to sweat. That's why she was shaking mad. I could be wrong, question mark. Yeah, she couldn't really kick him off without any reason to do so, and without giving him a chance to defend himself. And I don't know, I think there's so much more at play here than we know. And I think that it was a very odd reaction. And I just, for some reason, don't think that that's what it's about. But I could be wrong. And I guess we're going to see. Amber Bauer came with a 5 and said, did you see Brennan pat Alessi on the shoulder and smile at him right after court? No, I did not see that. But, it's a little bit cringy, yeah. So weird. I did see how Alessi went up to him at the beginning of the hearing and shook his hand. He was so kind to him. He's so nice to everybody all the time. Love him, Bobby Alessi, new fan favorite. New York attorney. Love that guy. He's working pro bono, as many of these attorneys are, as we know, which means for free. In fact, Alan and David have also said that they are working for free. As Alan Jackson told the world when he did that Ted Daniel interview, he says, yeah, maybe she owes us $5 million, but we don't expect that we're ever going to collect on that. We're not asking her for that. We believe strongly in this case and her innocence, and that's why we keep working. All the money that's been donated is going to experts. So if you have an extra $5, $1, whatever you have, and you're able to donate to the Karen Reed Defense Fund, and you feel like that is something that you want to do, please do that, because every dollar helps. Appeals are expensive, experts are expensive, and everything costs money. And the lawyers are working for free. So what does that tell you? It tells me a lot. It tells me they really believe in her case, as we do. Many of us do, right? I bid him. Chloe came in with a 5 and said, I honestly think Brennan didn't realize the facts of what he presented until Auntie Bev freaked out. Shows how reckless he is. They both are, in my opinion. I think a lot of people feel that way too. And I love when you guys say, in my opinion, instead of stating things as fact, because your opinions are your opinions, my opinions are my opinions. We're not always going to agree, but I'm always going to tell you what my opinions are, because it's not a neutral channel. I don't have to be neutral. I'm not a judge. I'm a lawyer. I have opinions, strong ones. That's why I became a lawyer. So I think that's why a lot of you are here. I don't know if we'll get to hear from Alessi on Tuesday, but there are some motions we didn't get to hear. And the big motion that he was going to argue is the motion to exclude Dr. Crosby. So we're going to take a look at the Commonwealth's opposition to that. I have some thoughts on why there are certain motions we didn't hear, but we're going to talk about that in a second. So let me just get through these super chats, and then we will get to that. I see you came in with a 5 and said, did you see Brennan charge out of the courtroom after her when she took that break? Sus. It was just a moment at the very end before the fan break. Yeah, then I saw some chatter about him walking out with a notebook and her walking in with a notebook. I don't know what to make of that. Again, speculation, hyperbole. I love that you guys are eagle-eyed and that you're on top of it. I just don't know what to think about it. If anything, what, if anything, to think about it? I don't know. Ashley came in and said, Ashley Linnell with a 5, do you think the feds were waiting on the writ? They normally don't schedule a hearing that quickly and take a small percentage of writs. That is an interesting thought. And I don't know. I don't know if the feds were working on it. I don't know what you mean by that, because it wasn't filed by the feds. It was filed by Marty Weinberg and Karen's team. For those of you who don't know, they have appealed Karen's SJC appellate denial to federal court and asked for a writ of mandamus for the federal court to now step in and overturn what the highest court in Massachusetts did by saying that the judge didn't do anything wrong by not polling the jury, that there is no official verdict, and therefore Karen Reed can be tried again on counts 1 and 3. They have asked the federal court to step in and overturn that. My understanding is the next step from this federal court, if the federal court grants it, the Commonwealth could appeal. I think the next appellate level would be the U.S. Supreme Court, which hears an even smaller percentage of cases. So I don't know where that's going to go. Clerk Jim, thank you. I misread this. You said interesting to see if the AG's office files a response. They will. They're obligated to, since they're named, yeah, as is the Norfolk Superior Court. So somebody will be appearing on their behalf, and yes, they will file absolutely a response. All right, after that, Free Karen Reed Fab 5 for the win came in with a 5 and said, I believe Hanky Boy was extremely upset with what Liza had to say about the Birchmore case and the connection with Karen's case. It's wild. I'm going to show you, we're going to go over the response to that, the Commonwealth's written response, because so many of the things that Brennan said in his argument were not in his papers. And I just found it odd that he got up there and said, she would look at him and say, do you have any opposition, Mr. Brennan? And he would get up and say, well, I don't really have an opposition, but I want to tell you my thoughts. Like, what the duck is that? if you want your thoughts known, you should have put them on paper instead of getting up and saying a whole bunch of stuff that is not in writing anywhere. All that stuff he said about Mark Betterow, and I will bet, and I haven't talked to Mark about it because, look, Mark is under a bubble now. He can't talk to me about the case. I can't talk to him about the case. So I know you guys miss him, but understand that if he's going to be an attorney of record on the Reed team, he can't talk about the case. So you're stuck with me. And so there's that. We'll look at their response to what they said about Birchmore and the fact that they think that the defense has not made a good faith showing to get unredacted copies of the Birchmore reports when they have possession of them because they can't see how they're related. Tells you pretty much everything you need to know about the Commonwealth and Brennan and what he thinks about what his job is, I guess. All right, and then we have Chastity gifted a membership, so thank you so much, Chastity. Moon Goddess came in with a 10, thank you, Moon Goddess, and said, everyone be sure to look up. Ice is falling from the roofs and it will kill you. Make sure you look up upon entering and leaving buildings, houses. Wow. That's crazy, Moon Goddess, but yeah, it can. Like, especially those giant icicles can be really, really sharp. And I think they have actually, like, taken lives of people before, right? And they're heavy. So yeah, people always say, I don't know, I heard once that the best weapon to commit, the M word with, which I guess we're in the first 16 minutes, we can say it, to commit murder with might be one of those giant icicles because, it can be very sharp and it probably could kill somebody and yet it would melt and there would be no weapon. I'm not giving anybody any ideas, just a fun thought that someone once brought to my attention. Decline came in with a 10 and said, you are amazing. Thank you for taking me off the ledge. It's so hard to believe that there is so much corruption. I know you guys have a hard time believing it. If you're not from Long Island, New York, maybe in general, and or Massachusetts, where you guys have been dealing with it for decades, but it does happen. It's been my opinion for a very long time that the Long Island serial killer Rex Heuermann was not caught in 2010 because of the corruption that was going on in Suffolk County, New York, by the police chief, James Burke, who eventually wound up in federal prison, and the district attorney, Tom Spoda, who were trying to say, look the other way. We may be doing some stuff that is nefarious. And so even though they had the description of Rex Heuermann all the way back in 2010 in the file, and trust me when I tell you that Rex Heuermann, it was described as being a 6'4" to 6'6" ogre driving a first generation green Chevy Avalanche. Had they done that DMV search and just searched up registrations in the Long Island area of green Chevy Avalanches registered to a man between 6'4" and 6'6", you can bet your bottom dollar that they probably would have found him pretty quickly. I'm just saying. I'm not sure. I'm just saying. So there's that. And so what I think happened is I think there were a lot of look the other way. The more I look at the papers that we didn't go over, or they didn't go over in court last week. What day was that hearing? Tuesday. It just made me think that it was just another one of those look the other way. Look over here, something shiny, look over here. Let's not pay attention to what's over here. You can let me know what you think, because we're going to go over the papers. New Hampshire woman became a new member. Thank you. Gina Gibson, thank you for becoming a member. Mary Stoll, thank you for becoming a member. And Barbara Dulong says, glad you're okay. I was worried. No, you guys, I'm always okay. I just don't post my whereabouts for a very good reason. I don't post personal things about my family for a very good reason. Those of you who choose to wade into the cesspool of Twitter know why. You see what they're doing to Dr. Wolf and his family. You see what they have done to Richard Green. You see what is going on with many of the other players that are simply speaking out about Karen Reed not hitting John O'Keefe with a car, because John O'Keefe was not hit by a car. The injuries don't tell that story. They just don't. Thank you so much for being worried, Barbara. I love you with all of my heart, and you're very sweet. The Goodmans are here. They've gifted a membership. Good morning, Goodmans. Good morning. On top, thank you very much for your super sticker, and you're always on top. Tracy Walker, you're relatively new to this channel, unless you had a different name before. But girl, you have come in here and you have gifted something like close to 200 memberships during the last 3 to 5 streams, and I don't even know how to thank you. But I'm going to thank you again publicly. And for those 10 who were gifted, Tracy Walker is on fire. Thank you so much. Aizen is here and says, I agree with you, Melanie. He's a drama queen. He's a drama queen, right? I think so. It's maybe a deflection tactic, right? Don't look at the metadata. We don't need to give you metadata. All you need to do is click and drop and drag. We don't need to give you anything to prove the truth and veracity of the evidence that we want you to convict a woman of murder on. What do you mean metadata? Metadata, metadata. My name is Hank Breenan, and I don't know nothing about metadata, and you don't need the metadata anyway. Why should I have to give it to you? It's wild. I've never seen this. Like, this is blowing minds of lawyers everywhere, not just me. Tammy Truth and Justice says, thank you for what you do, keeping it real. Thank you for being here, Tammy, for 10 months. You're awesome. You're all awesome. Look at Lady Zelda is here. Thank you for the 50. That's very generous of you, Lady Zelda. Thank you for all that you do and taking your time on your vacay to be with us. You have the voice of reason. Much love to you. I try and calm you guys down. I don't think there's anything you get worked up about. Lady Zelda Kelly reads tarot cards. She's amazing. She's done a lot of videos on the Karen Read case. If you like that sort of stuff, go over there and listen to her. She's got a very soothing voice, and she does great work. Check it out. Women helping other women, right? I love it. And Boozy Beauty, too. I don't know if you're here, as I said before, but well, we'll see. Common sense should prevail says, can a lawyer still work on a case behind the scenes, like briefs and motions, even if they're not pro-hawked in? As long as you're not appearing as the attorney of record on anything. I mean, they've got interns working for them who are doing plenty of research and drafting plenty of things. It just has to have a lawyer's name on it, who is the attorney of record, one of the attorneys of record on that actual case in that actual courthouse or in the bar, admitted even pro hoc to the state in which the case resides. Elf, thanks for hanging out for 13 months. Spanky exhibits passive aggressive behavior. Yeah, weird, right? Oddly outraged at things that he may not exactly have proof on, which I find to be odd, hyperbolic, and maybe less than truthful. We'll see. Hi, Suze. The writ hearing is the same day as another motion hearing, 3-5. There may be audio live streaming. Yeah, there's going to be a busy day. I think it doesn't also, isn't that the day that Aidan Carney's motion to dismiss is going to be heard that we went over? So March 5th is a big day. So we've got a lot to do that day. So we'll be here for all of it. Bernie says, Melanie, I truly resent the gaslighting Brennan is doing. It shows what contempt he has for us and how little truth matters to him. I'm beyond irked. Bernie, who also is really irked, surprisingly, is Vinnie Politan, who traditionally has not been as outspoken as I have about the Karen Read case, but I feel like he sort of came around. We looked at part of his stream one day on his own personal YouTube channel, in which he said, listen, the prosecutor is supposed to be after the truth, not a conviction. Why would they fight to keep out the ARCA experts if they really wanted to get at the truth? And he makes a lot of sense. And it's good, Bernie, that you can recognize it is gaslighting and treat it that way. I mean, part of pointing out a problem is recognizing the problem, right? Lori, like, you're amazing. You're from Canada. You're always super chatting and always gifting and commenting respectfully, and I appreciate you so much. It says, thank you for gifting us with a take two, like a boss. Well, I hate to leave something half finished. And it's wild because it was only a 20-minute video yesterday, and that kind of cut off as I was trying to get back in. And so many people were in the comments like, this was fantastic. Like, they said, even when you were off screen, I had to stay and watch the chat because the chat was hilarious. And I unfortunately didn't get a chance to go back and watch it. I usually try and go back and watch the chat. But you guys were on fire yesterday. You are the snark tank. You're hilarious. Keep up the good work, you guys. Keep up the good work. Hi, Mike. I just got here. Did you go over Beb saying the lawyers can't appear by Zoom? Hope you're having a nice time away. Thank you. Thank you. I'm going to go over that order. I don't know where she said. Did she say in that order they can't appear by Zoom? I don't know. I will take a look. Kyle's here. He's always super chatting upside down. Now Bev is upset. Kyle, I think that there is something more. I think there's something more to it. I don't know exactly what it is. It's pointless for me to speculate, but I think something is rotten in Denmark, not just in Denmark, but Norfolk County. Hector's mom is here. She became a new member, and I'm sure she's a great amazing mom. All right, let us first go to the order that came down after. It's a notice to appear for continued hearing. This is the challenge. The challenge is that I don't have a second screen here, so putting documents up and reading them is going to be a little challenging, but you know what? I'm always up for challenge, as you know. So let's see what we can do here. This is docket number 513, docket number 513. And this is entitled Commonwealth versus Karen Reed, notice to appear for continued hearing. On February 25th, 2025 at 11 a.m., the court will reconvene the hearing that began on February 18th, 2025. Counsel should be prepared to address issues related to defendant's recent production pursuant to Rule 14, especially as the materials produced relate to prior representations made to the court on the record by defense counsel concerning the ARCA witnesses. And I'm just going to point out again, Boozy Beauty did a better timeline that I'm going to go over with you. Oh, thank you, Jessica, for recommending a second screen. I'm traveling, so that's the reason that I don't have one. I have an HDMI cable to hook up to that giant TV over there, but the Ethernet cable wouldn't reach. It's a whole thing. Thank you. When I'm home, I have an amazing setup, but here I am out here in the wild. The wild. So thank you. Love you, girl. Appreciate you so much. I'm on location. Yes, I am on location, as you can see, and it's a beautiful day here. The timeline. In open court, June 10th, David Yannetti got up and said, "We have not been able to speak to the ARCA witnesses yet." The rest of the communications happened after that. So when David Yannetti got up and spoke in court on the 10th of June, was he lying? I don't think so. So this is going to turn out to be something crazy. The original communications from Alan to Dr. Wolf in March, he reached out to say, "Can we retain you?" Dr. Wolf said, "No, you can't. We're still under." The feds have said no. It was shut down. That's why I think this reaction, this overblown reaction by the judge, where she came back visibly shaking and like with like almost tremors, like it was something happened in that half an hour where she left the bench. I don't know what it is. A lot of people have pointed out there was a huge police presence in the back of the room. There was a guy who looked like he was FBI with a pin. I think he's the head of the court officers. I think he's been in and out throughout the entire trial. I don't know. Did she get the news during that break that the writ of habeas corpus had been actually heard quickly by a judge who set a briefing schedule? Would that rattle her? I don't know. Judges are appealed all the time. There was nothing. I read the papers. It's 700 pages. Most of it is the record on appeal. 35 pages is the brief. There's really nothing new in there that points to any accusations against the judge. And so I don't think that was it. But again, I don't know. We could speculate all day. If you want to spend the whole day speculating, we could, but it might be fun, except what's the point, right? Wait till Tuesday. Till Tuesday was in my title. And for those of you who got the reference to that band from the 90s or 80s or from whenever they were from, they sang a song called Voices Carry, which was pretty good. Till Tuesday. That was a pretty good band. They were pretty good. In addition, because the Commonwealth referenced a transcript of a hearing on June 10th, 2024, at the hearing on February 18th, 2025, the Commonwealth is to provide a copy of that transcript to the defense and the court by close of business on February 21st, 2025. I don't see in here where it says they can't appear by Zoom. But I'm sure that Alan Jackson, who's going to be coming in to defend his integrity, his honor, and the not so veiled accusations of violating the rules of professional ethics by Hank Brennan, as was Mark Petterow, by the way, accused by Hank Brennan of improper activities, let's just say, I'm pretty sure he's going to show up in person anyway. Wouldn't you? The fact that he wasn't even given an opportunity to be heard is wild to me. So I don't see where it says he can't appear by Zoom. But again, I think he's probably most likely going to show up. So there's going to be here, and I don't know if that's the only thing they're going to be hearing, because remember, there's still a couple of motions that they didn't get to, right? So there's that. The motion to dismiss has not been docketed. Has it been filed? Probably. I'm going to check the docket again, but last I checked it after close of business yesterday, it was not. It had not yet been filed. You notice what happened last week when we thought we were going to get the papers that had been filed before the hearing, the day before the hearing. We thought we were going to get to review them the morning of the hearing, and unfortunately, sadly, they did not actually hit the docket. They were logged in, but not scanned in, and so we couldn't review them, but we have them now, so we can take a look at them. Every time I go in there to look at the Karen Reed docket, it's almost like everyone is looking at it, so it's very slow, this Mass Court's website, but let me see what I can find. The last thing that was filed was Hank Brennan wanted to impound an exhibit. It was, I think, an audio recording that was obtained through the Gretchen Voss documents, and he wanted to impound that part of an exhibit on his motion for sanctions, which we need to take a look at because we still haven't taken a look at that either. So it was granted. Just, she wrote on the bottom of it, granted. So there's that. And then there's a new notice of discovery. The Commonwealth is still turning over discovery. We're going to take a look at that. And what should we look at first? First thing I think I want to look at is okay, this is what we're going to look at first. The Commonwealth's response to defendant's motion to compel discovery, that is 502, because that talks about the Birchmore documents. And that is in response to docket number 495 by the defense. So we kind of need to look at them in conjunction with each other. I'm going to try and not keep too many tabs open today so that we don't lose, memory. I don't know. I need a whole entire tech support team. So there's that. Okay. All right. So let us take a look at Brennan's written response, because I think he did argue this in court. Oh, we got a nice crowd. We got a nice crowd for a Saturday morning. Yeah, smash that like button. Helps the algorithm and all that kind of good stuff. All that kind of good stuff. All right. What is going on here? What is going on? This is docket number 495. That's not the one I want. I want 502. All right. So here, I've had a chance to redline all this stuff too, because I had some time on the airplane in which to get this done. Okay, so the Commonwealth's response. This is the Commonwealth's response to the defendant's motion to compel discovery. And this is the stuff that Hank Brennan was arguing that he should not have to turn over in court. And this is wild to me, because as we know that at least Michael Morrissey is very, very familiar with his obligations, right? Under Brady, because of all of those crazy letters that he was exchanging with Josh Levy's office all the way back in, I think they started in May of 2023 when they found out that there was a federal grand jury convened in this case. And Michael Morrissey was sending crazy letters to Josh Levy. And I did an entire stream on that. You can go back and find it in the Karen Reed pretrial playlist. And it has something, it says, I don't know what the title is, something about Morrissey's letters. But he, in every single letter that ramps up in its frantic sort of hysteria, repeatedly says, we have obligations under Brady. We need to know what you're investigating. We need to know, we need all of the transcripts. We need to know what you know. We need all of your discovery in that federal case because we are required under Brady to exchange that with the defense. And we have obligations. And he went on and on and on and on. Do you guys remember? And so they're well aware of their obligations under Brady. So when he gets in here as the new guy and acts like, yeah, why should we have to turn this over? It's wild to me because those of you who have been following this case with me since January of 2024 know we've been over every inch pretty much of this case, every inch. So here's how Hank Brennan chooses to respond. This is docket number 502, and this is response to the motion 495, the defendant's motion to compel. The first thing that the defendants asked for is all chain of custody logs, reports, evidence logs, and or other documentation regarding how the district attorney's office and or state police came into the possession of each distinct production of video surveillance footage from Canton PD that has been provided to the defense. And here's Hank's response to that. The Commonwealth agrees to the extent such items and information exist and are within the control and custody of the Commonwealth. The Commonwealth is not obligated under Rule 14 to create any timelines or work product logs that do not exist. Read between the lines, my friends. What is he saying there? They don't exist and we're not going to create them for you. We're not going to tell you where that video came from. We don't have an obligation to do that. And so no. And remember what the judge said during the hearing last week. She said, and I think it was Liza Little that was arguing this, right? And she said, Ms. Little, do you expect them to create a log that doesn't exist? And this is insane. It's insane. Mom Avino, I'm going to star that for later. So if I see questions flying by that I like, I'm going to just, or that I want to address or that need addressing, I'm going to star them for later. So don't worry. Mastad is here. Good morning. Nothing to discuss. Canoni's waiting for an affidavit for the statute. I don't know what you're talking about, but let me go back and see what question that is. I don't know. Mastad, for your information, has been working in the legal field in Massachusetts for many, many, many years. Not as long as I have in New York, but close to it. So when he says stuff, he's usually right on the money. So they don't think that they should have to create any sort of log or chain of custody or even tell them where these little clips came out in dribs and drabs. Oh, whether they'll discuss better. Oh, okay, great. Thank you. Thank you so much. Yes, she told, that is correct. You are absolutely, as always, correct, Mastad. Judge Canoni told David Iannetti to submit a supplemental affidavit giving more information on why Mark Betterow is needed and what special skills he has. Give me better reasons. Give me more reasons that I should admit him pro hoc vice when you already have a lot of attorneys. More detail. Amy says, overtly admitting how shady they are. Yeah. We don't know where we have to, why we should have to recreate that for you. And it's, in what other world would a prosecutor hand over evidence that they tend to rely on at trial that doesn't have metadata? And I see some questions in the chat about whether it's admissible. It may go to the weight of the evidence in Massachusetts and not its admissibility. In New York, I think a very good argument could be made that it's not the best evidence because there is no metadata and it would not be allowed in based on that. Same thing with screenshots and other stuff. But in this court, seems to be like anything goes. Oh, and by the way, you can cross-examine them and try and impeach them. But if you want to impeach them, you have to give the other side your impeachment evidence so that they know what you're going to impeach them on, so that you can prep them for it. Because here we are in the land of the upside down, the make-believe, Narnia, the Matrix. We're here in this black hole of Norfolk County, Massachusetts, and it's like we've fallen and we can't get up. I don't know how many metaphors I can put in one sentence, but that was a lot. Here, the next thing that the defense asked for was an unredacted copy of the police report regarding Sandra Birchmore. Here's Hank's very brief response. The Commonwealth objects as beyond the scope of Rule 14. The defense has made absolutely no showing that the request is material and relevant to this case. Really? Because in the defendant's original motion, which we went over and I have up on my other tab, which I cannot put up at the same time as this one, the argument made by defendants was that defendant, hold on, is that the investigation into the death of Sandra Birchmore has involved many of the material witnesses in Ms. Reed's case, including but not limited to. And I love the way Ms. Little, no relation, got up in court and named the names. Sergeant Michael Lank, Daniel Whitley, Trooper Michael Dunn, Trooper Zach Clark, Colleen Crawford, Detective Kevin Albert, Lieutenant John Fanning, who, by the way, was also in charge of the jury in the Karen Reed case, Trooper Reno, aka Trooper Nicholas Garino, Lieutenant Brian Tully, Deputy District Attorney Lynn Beland, and District Attorney Michael Marcy. They went on to say in their motion, the defense, given the similar allegations of misconduct by state actors in the Birchmore and Reed case, the statements that material witnesses in Ms. Reed's case made in relation to the Birchmore investigation are relevant for impeachment and bear on the credibility of those witnesses in the instant matter. Despite defense counsel's request, the Commonwealth had not yet provided the defense with that report, number 26, unredacted. And then the motion went on to say, in fact, Attorney Brennan replied on November 25th that because the Sandra Birchmore case now involves a federal investigation, defense counsel should seek the redacted information from the U.S. Attorney's Office, even though the Commonwealth has possession, custody, and control of the unredacted report, which is a deflection. Look over here, look over there. We don't have it. We shouldn't have to give it to you. You haven't shown that it's material and relevant. What? The papers went on to say that these unredacted reports include statements by material witnesses in the Karen Reed matter. Many of those statements have since been undermined and discredited, and that consequently they bear on the credibility of those material witnesses and are directly relevant to Ms. Reed's case. And they say the fact that the U.S. Attorney's Office may have redacted information does not absolve the Commonwealth of their obligation to provide mandatory discovery under Rule 14. And Hank Brennan has the audacity to say in his response, the defense has made absolutely no showing that the request is material and relevant to this case. Okay. This was one of the few motions that was argued in open court the other day that no decision was made on. Clerk Jim Clown is here and says what we're all thinking. Fanning being named opens certain doors that the judge needs to remain closed. Yes. Yes. Tell me, do you think the defense made a showing that it's material and relevant evidence that they should be entitled to? This is like, again, we're in the upside down. Here's Hank Brennan's response to number 3, in which defense made a request for an unredacted copy of the public record response relating to all email correspondence and communications associated with the Sandra Birchmore investigation. And again, Brenna's response: the Commonwealth objects as beyond the scope of Rule 14. The defense has made absolutely no showing that the request is material and relevant in this case. That is a boilerplate response to an anything but boilerplate demand. To go back to the motion, the defense motion in their request for number 3, the argument was that defense asked for it on November 8th from the Commonwealth. The Commonwealth responded and gave them the redacted copy. They said, we want the unredacted copy. And again, told them to go to the U.S. Attorney's Office if they want it. Defense goes on to argue it's the legal obligation of the Commonwealth to provide such information when it's within its possession, custody, and control. And so turn it over. Their argument is that you haven't made a good enough showing of why you need it. Aside from the however many people that we just listed that were involved in both investigations. And for those of you who are not familiar with the Sandra Birchmore case, Sandra Birchmore, I think she was 23 years old when she was found with a strap around her neck, hanging from a doorknob in her apartment in Canton. Canton PD were the first to investigate that case, and MSP got involved, quickly ruled it a suicide, despite the fact that there was a lot of evidence that Sandra Birchmore was having an affair with a married Stoughton police officer named Matthew Farwell, who, upon further digging, not really so much digging, because all of this was in text messages that were in Sandra's computer, had met police officer Matthew Farwell during her time as a young explorer in the Police Explorers program when she was maybe 11 or 12. I don't know, don't quote me on the exact ages, but that's where he met her. He took her virginity when she was 15. All that was contained within their text messages, and then impregnated her at 23. And the feds had to get involved in that case. And now Matthew Farwell is under indictment, federal indictment, for murdering a witness. The state still hasn't brought murder charges against Matthew Farwell. And so the fact that that case also involved perhaps some of the same investigators covering up for a cop, and the issues in the Karen Reed case are eerily similar. Perhaps some of the same players covering up for other cops. That's not material and relevant is wild to me. Cause of death is now homicide, not suicide. There was video of Matthew Farwell in her apartment, in the lobby of her apartment, like day before she went missing, night before she went missing, something like that. I have a whole playlist on it. If you're interested, go watch it. There's like 5 videos. That's not relevant. Trooper Nicholas Garino apparently was the forensic examiner, let's say, on the cellular forensics of Stoughton police officer Matthew Farwell at the time, and said that he could not find any text messages between Matthew Farwell and Sandra Birchmore on his phone. Don't know how deeply he dug, but on Sandra Birchmore's laptop were approximately 32,000 messages between the two, maybe 34,000. Again, don't come for me for numbers today because not enough coffee, but that's not material and relevant. Same players, same police involvement, cover up. What? Again, wild to me. Hank's opposition to number 4. Same thing about Sandra Birchmore, the handwritten law enforcement notes or other documents. He says it's beyond the scope. Defense made a similar argument in their motion. Again, naming names. All of these same players were involved in Karen Reed's case and Sandra Birchmore's case. Michael Lenk, Daniel Whitley, Trooper Mike Dunn, Trooper Zach Clark, Colleen Crawford, Detective Kevin Albert, Lieutenant John Fanning, Trooper Garino, Lieutenant Brian Tully, ADA Lynn Beland, or DDA, and DA Michael Marcy. Given the similar allegations of misconduct by state actors in the Birchmore and Reed cases, the statements that material witnesses in Ms. Reed's case made in relation to the Birchmore investigation are relevant for impeachment and bear on credibility of those witnesses in the instant matter. And it kind of seems obvious, right? But no, Brennan doesn't want to turn it over. Wild. With regard to number 5, and that is the communications documents, writings relating to the internal affairs investigation into Trooper Michael Proctor, including transcripts of administrative proceedings. Brennan's response is the Norfolk District Attorney's Office has provided all material regarding Trooper Proctor's internal affairs investigation that is presently within its custody and control. And they go on to cite some case law in which they state that the Supreme Court, the SJC, has deemed internal affairs divisions to be outside the scope of the prosecution team, and therefore rejected any suggestion that internal affairs records, even if relevant and material, must be produced by the prosecution because they fall outside of the prosecutor's possession. With regard to number 6, all material and relevant communications made between members of law enforcement and witnesses in this case, including but not limited to Sergeant Yuri Buchanan and Chris Albert by email and or cell phone from January 29th to present. Surprisingly, Hank Brennan has no objection to that. He says they're going to continue to provide statements of witnesses and all material the defendant is entitled to under Rule 14. And remember, in the motion by the defense, they pointed out text messages between Yuri Buchanan and Chris Albert regarding some women who are outside D&E Pizza. Chris Albert texted Yuri Buchanan on July 10th, 2024, after the first trial. And this was in a police report that Buchanan filed, by the way. Buchanan attached screenshots of his text messages with Chris Albert in that police report, in which Chris Albert wrote to Yuri Buchanan, hey, so I just had 2 women outside my shop taking pictures, which is fine. Then one woman lifted her hand and made a gun motion to her head. I watched it and have on video, ! Sergeant Buchanan responded, please email it to me, and wrote, do you know who these women are? Chris Albert replied, no clue, I'll email to you. In his report, Sergeant Buchanan also acknowledged that Chris Albert is one of the Commonwealth's witnesses in a murder case. So apparently Chris Albert had Yuri Buchanan on speed dial, just in case, he wanted to file charges against anybody that he may have felt was intimidating him by going like this with their finger. And under Massachusetts law, Sergeant Buchanan is an active member of the prosecution team because these state troopers are assigned to the Norfolk County DA's office. So therefore, turn it over. He says he will. We'll see. Number 7, he also has no objection to, which is all copies of all notes and correspondence regarding any testing conducted in this case, along with all research and materials relied upon by the Commonwealth's experts in completing their analysis, regardless of whether the witness will be testifying to the information at trial. They have no objection to that. They said they've already produced, and so they blew past that. Next. Request number 8, the defense is looking for all communications between members of the Norfolk County District Attorney's Office and or its law enforcement agents on the one hand, and all experts retained by the Commonwealth in connection with this case include date and substance of phone calls, copies of any written correspondence, dates of any strategy meetings, and list of materials received. And Brennan's response is that that request is overly broad and beyond the scope of Rule 14. But they want all that stuff from the defense, so make it make sense. Next, they're looking for all written communications, including emails and text messages between any members of the Norfolk DA's office and or its law enforcement agents and any expert the Commonwealth intends to call a trial. Again, they say that's overly broad under Rule 14, and the defendant is not entitled to the Commonwealth's work product, including its legal research, opinions, theories, or mental impressions. And response request number 10. Which in the motion is described as the Commonwealth produced a series of text messages in Bates stamp number, and they give some numbers there, which are completely illegible. The defense requests that the Commonwealth immediately produce a legible copy of these communications. I don't know who they're between. And Hank responds to that he will produce those. So I guess we should feel lucky about that. And of course, in true Judge Cannoni form, there's been no decision on that. She did not rule on that from the bench. Let's go to the chat. Mom Bearcat says, Hank reminds me of Frank Burns on MASH. Well done. Kathy's Legs has been here for 10 months and says, Bev's anxiety is only for her own ass. Yeah, I found it to be a very odd reaction. And so I thought it was something more personal. So I just don't know what it is. But again, chime in. Kyle says, didn't they argue bias? Bev made that is on the record. The defense argued bias, yes. Oh, she's mad that that's on the record. Maybe. Perhaps. Could be. Could be, Kyle. Good point. Michelle, thanks for the 10. Your channel has become my life. Oh, goodness. That's a lot of pressure for me, Michelle, but thank you. Appreciate the legal insight. How can they just continue to keep getting away with this? What can be done? It's so outrageous, corrupt. I just can't believe my eyes in every hearing. Just keep paying attention, you guys. Keep paying attention, keep watching, keep showing up, keep sharing it out. You know, just the best you can. Let people know what's going on. It's a worldwide story now. Just is. Oh, Dream, Karen Reed's Revenge. Thanks for the 50. It says, good morning. I'm still lost as to all the evidence was even allowed in when there is no chain of custody. I am baffled. Aren't we all? And the defense did their best to cross-examine on all of that. You know, that inverted Sallyport video? There's really no explanation of where that came from. And under Hank Brennan's own argument, he shouldn't have to create something that doesn't exist. And there's no criminal depositions in Massachusetts, as there are in many other states. So it's not like they can do a deposition of Colleen Crawford to find out where that video came from. Or anyone, really. It's just like flying blind, which again, thank you again, Dream Karen Reed's Revenge for your 50. We're all baffled. Mama Vino says, can you please explain, isn't Karen Reed the one entitled to a fair trial? Yes, yes, she is. That's a constitutional right of every defendant to be afforded a fair trial. I'm so confused every time Brennan argues that the Commonwealth is entitled to a fair trial. It's upside down. Yeah, it's upside down. Also, he's a defense attorney. He's used to arguing that on behalf of his clients. So it's wild and crazy. And it just keeps getting crazier. That said, the defense does have obligations to turn over certain things automatically. Mandatory. But their obligation does not start to run until the Commonwealth has finished turning over all discovery and filed their certificate of compliance, which they did. And yet again, they served another notice of discovery after they filed their certificate of compliance, which means to me that they're still not done because things just keep appearing. Even portions of Sallyport video that they've had in their possession since January 29th of 2022. Like the new video of Karen Reed's Lexus backing into the Sallyport, which Alan Jackson says is exculpatory. Are the walls closing in on the Commonwealth? I don't know. Seems like all of this stuff is happening at the same time. So it's kind of crazy. Lisa Marie in Tennessee says the same thing. How can evidence be admitted in trial without a chain of custody? That's what motions in lemonade are for. And the closed captions are still calling them motions in lemonade. They are, of course, motions in limine, which are made to exclude certain evidence from trial and to get a ruling on that before trial, and also to include certain evidence at trial. You can expect there will be motions in lemonade made with regard to some of these things. But again, judicial discretion. The judge is the gatekeeper. So the judge in Massachusetts can agree to allow it in and just say, oh, any arguments you have go to the weight of the evidence, and you can cross-examine on that. Not its admissibility, because I'm the gatekeeper. I get to decide what's admissible and what's not. It has to be authenticated. There has to be a foundation laid for it. But again, Mr. Jackson, this is the way we do things in Massachusetts, and it is a privilege to practice here, as you know. So, gatekeeper. Thanks, Lisa Marie in Tennessee. Sherry says, I feel like Massachusetts is just helping with an appeal. We'll see. Kyle, no metadata, chain report, even a note on napkins. Nope. And why should they have to create something that doesn't exist? Because, puts an extra burden on the Commonwealth. Because don't they have a big enough burden proving their case here? Proving that Karen Read committed murder in the second degree by intentionally backing her car up into John O'Keefe at 24 miles an hour in reverse for 60 feet. And yet none of the curtain twitchers inside 34 Fairview looking out the window every couple of seconds to see Karen Read's Lexus moving up and up and up and up saw that happen or heard it happen, or nobody who ever left the house after that saw a body on the lawn. Lucky Loughran, the impartial third-party witness, didn't see a body on the lawn either, and that's their burden. So, yeah, it's crazy. Mo, thanks for the 5. Did you see Video Jesus Abby on Young Jerks? No, I did not. The video existed during the first trial. You can see it on Lally's computer. That was showed by accident. Which video are we talking about? The inverted video that they showed? The video of Karen Read's Lexus backing in? That's wild. I did not see it, so I cannot comment on it. But thank you. I barely have time to do my own shows, no less watch anyone else's, although often I am lurking in chat. And I do often lurk in Young Jerks and Glare and everybody else that you've mentioned. Peter Tragos, Emily Baker. I lurk, but I watch them after I do my own shows because I don't want what they say to formulate my own opinion. And oftentimes I go to their channels and fast forward to certain parts so that I could see if we all reacted in the same way. And I find it crazy and fun to find out that we often do. The Rubber Duck says, have you guys talked about the memorandum of petition for writ of habeas corpus by the defense yet? Nope, we haven't. There's not a whole lot of new stuff in there, but we have mentioned that it's going to be argued on March 5th. If you have any specific questions about it, we can. It's 700 pages, 35 of which are the brief. The brief is the same arguments that we've been talking about all along with regard to double jeopardy and the jurors and what the jurors said after the trial, and makes some good arguments. If you can point out anything specifically new in there that you want to talk about, we can. So I kind of addressed that at the beginning, broadly and briefly, but I don't think that we need to read it. Other people have done that. You can go watch that somewhere else. And also, it's pretty much the same arguments. I mean, I didn't really notice anything glaringly different about it, unless I missed something that you guys want to point out to me. Laura Croft, thank you for the 10, says, so he said he read the trial transcript. I wonder if he would swear to that under oath. I don't know. So I have to take a polygraph too, which reminds me of something I watched last night and I could not sleep. I'll tell you in a second. How many people sitting at the prosecution table also participated in the trial? Maybe they should talk. Well, maybe my opinion has been and continues to be that perhaps, perhaps, Lally's not helping him on purpose. I don't know. He might have some personal beef about the whole thing of Hank Brennan being brought in to unseat him, really dethrone him, right? So I don't know. And Lally could be a witness. You're right, though, Laura. Lally could be called as a witness with regard to where he got that inverted Sallyport video from, because nobody seems to know. The only person who hasn't been asked, one of the people who hasn't been asked, is Lally. He came into possession of it somehow in the middle of trial. Could he be a fact witness about where that came from? Yeah. The Commonwealth shouldn't have to, create anything, but, could Lally be questioned at a motion in lemonade hearing? Perhaps. Perhaps he could. AJ's full-throated motion is here and says, the Commonwealth's whole credulity straining self is beyond the scope. Duck and nuts. Yeah, it does strain credulity in so many ways. I have merch. Thank you for bringing that up. AJ's full-throated motion. Piney Woods is here with a 10 and says, Bev should not let any unauthenticated metadata chain of custody in. Unauthenticated evidence. It is inadmissible, period. Again, it may go to the weight and not the admissibility in Massachusetts. They seem to have some pretty ducked up rules there. So can you expect some motions in lemonade about this? Yes. Did that video show up in the middle of trial last time? Yes. Motions in lemonade are made prior to trial. That's why we didn't see it. We don't know what was talked about at sidebar. But I'm pretty sure it's going to be in the motion to dismiss, which we have not seen yet, which I'm sure was timely filed. It just has not been docketed. So we will have a big day on Monday going over that whole entire motion, because I can't wait. I, for one, am on the edge of my seat. Emma is here from Ireland. Fairy Raven Emma is here and says, absolutely loving holiday mode, Melanie. The snark is off the chain and providing me with much needed actual laughing out louds. Thank you, Emma. Love you, girl. All of my heart. Monique is here, Coach Mo, and says, for 7 months, just an FYI, AJ said he has a hearing on the 24th. He needs to fly on the 24th to be in Massachusetts. Bev says, so you can be on Zoom if you want. Oh, I know. I would bet that he will reschedule that hearing. Tell that judge he's got to be in Massachusetts, so that is a possibility. Just because he has the hearing doesn't mean it can't be adjourned, right? I don't think he's going to show up on Zoom for this, especially when Brennan has at least, openly accused him of ethical violations in court. And perhaps tampering with a federal witness or whatever all these crazy theories people have out there, misstating, lying to the court. I don't think he's going to show up on Zoom. She did say he could, but I don't think he will. Laura says, is there any validity to the fact that the court staff was called to the federal building right after Auntie Bev dismissed the hearing last Tuesday? Don't know. I cannot speak to the truth and veracity of that. I don't know anything about it. Kyle, it's a portal, red plastic, and files keep appearing. It's what it feels like. The Matrix, a portal, Narnia, Lion, the Witch, and the Wardrobe, all that good stuff. Cumulus Cloud says, Brennan is defending the Commonwealth not being an ethical prosecutor. A lot of people feel that way. Jerry's here from Canada. Why does Bev need more details on Mark? He's goodero at this and bettero at that. Oh, well done, Jerry Gray. Everybody give Jerry Gray a golf clap today. Well done, sir. I'm impressed. Well done. Isn't that enough? Well, she did the same thing when they wanted Alessi and Pro Hoc Vice. She wanted more detail. She's entitled to it. She's the gatekeeper. But I think that's a rhetorical question, and I like it. I'll allow it. Thank you, Jerry Gray. Thank you, Hank's Lying Pie Hole, for being a member for 9 months. I see that you've probably changed your name. And well done. It is a competition for names that match the Karen Reed trial. And you guys are on fire with it. And maybe one day we'll have a competition and you guys can vote on your favorite names. And you can nominate the names, and I don't know, we can have like a little award ceremony or something. Decline says curtain snitchers. Oh, curtain snitchers. I call them curtain twitchers. And you know where I got that from? Kathy, our friend from Gossip, Rumor, and Innuendo. That's what she calls the nosy neighbors that are always twitching, always peeking out the curtains. The curtain twitchers. So I stole it from her and I love it. But curtain snitchers is good too. Thanks, Decline. Appreciate you. I love you with all of my heart. Clerk Jim Clown has been here for 2 months and says, thanks for being awesome. Thank you, guys are amazing. Kelly Cal is here with a 10 and says, I hate how Brennan keeps saying he invited the defendant to see the hard drive. Oh yeah, we're going to do that next. Thank you. Thank you, Kelly Cal. We're going to read that response next. Why didn't he go to the police station before having the expert come? He seems to be not trying that hard, really not trying. Well, This is a great segue into the next thing we're going to look at. So hold, please. Hold, please. This is yes, docket number 506 and 507, which is in response to defense motion to produce a forensically sound copy. Hang on one second. Which is docket number. Talk amongst yourselves for a second. Talk amongst yourselves. What the what? What the what? Is that it? Motion to compel? No, that's one motion to compel. Motion to exclude cross. Well, I can't find the exact motion right now, but let's look at the opposition anyway. So this is, about the metadata. Thank you, Kelly Keller, for your 10. I appreciate you so very much. Good citizen, thank you for the 10. Hey, girl. Can Bev dictate a deadline when a motion to dismiss needs to be dismissed? No, needs to be filed is what I think you mean. And yes, of course, she can. That's pretrial scheduling, and she's allowed to make deadlines, and that is part of the deadline schedule. So it should have been filed yesterday. My feelings are that it was filed. It just didn't hit the docket. It wasn't scanned because maybe they didn't want people like me talking about it all weekend and your other favorite law tubers and content creators. Maybe. Thank you. I'm having an amazing short vacation, but much needed. All right, let's get back to that. Okay, thank you, good citizen, for your super chat. You are amazing. All right, this is Brennan's response to the defendant's motion to compel production of a forensically sound copy of the January 29th, 2022 video surveillance footage in law enforcement custody, which is, as you know, the Canton Sallyport video. Background, it's only 4 pages, let's read it. After informing the defense that copies of some footage exists on a data file at the Canton Police Department, and now they're calling it the detective file, which we know was kept by a retired detective. How convenient. A retired detective from the Canton Police Department. The Commonwealth's multiple attempts to provide the footage to the defense have become unnecessarily bogged down by needless attempts to complicate the process, okay? This is what you call projection. I'm sorry, the Commonwealth has been unnecessarily bogged down because the defense is needlessly trying to complicate the process. Footnote number 1 says, despite vacillating and frustrating the production of this discovery, the defense actually cites their delay of this production as one of the bases for its opposition to reciprocal discovery. Because remember, they sent their expert from Phoenix to the Canton Police Department as scheduled with Hank Brennan and Colleen Crawford. And then when the expert got there, the expert was told, what are you talking about? We don't have it. It doesn't exist on our server. Our DVR, NDR, whatever they're calling it now. So that was a waste of time and trip. Defense made a motion for costs and expenses related to that expert having to fly there for nothing. for $12,000 and change, and that motion was denied by the judge, which I found surprising. I believe in New York that would have been granted, but we're not in Kansas anymore, kids. The response goes on to say, whatever footage exists can and should be produced consistent with the standard practice of reproducing stored video. Standard practice of reproducing stored video. I am not a video Jesus, but I'm sure there are some out there, I know there are, who can explain this better than I can. And then goes on to say, with a straight face, the Commonwealth simply needs to the Commonwealth simply needs to click and drag copies of any stored videos to a hard drive and produce the material to the defense. The Commonwealth previously provided the defense an opportunity to attend and participate in this very basic and uneventful procedure. After the defense deferred on taking a position, the court at the February 6th hearing directed the parties to meet and attempt to reach an agreement. Immediately following that court hearing on February 6th, 4 attorneys from the Commonwealth see accompanying affidavit, because now he knows he needs to attach an affidavit to his motions or his replies. Along with Attorney Jackson and Attorney Yannetti, remained in the courtroom and met to reach an agreement. The parties agreed that the Commonwealth would have a person copy the video files from the detective file and store the videos on a hard drive and then produce a copy to the defense. The Commonwealth also suggested and agreed that it would videotape the procedure. You're gonna videotape somebody clicking and dragging something onto a hard drive? Okay. The Commonwealth memorialized the parties' agreement in writing and sent it to the defense. Although she had not been in court on February 6th and did not participate in the parties' meeting and agreement, Attorney Little began lodging emails attempting to alter and change the agreement that was already made between the parties. There's some shade on Liza because she wasn't at the meeting. And then she's the one that started emailing Judge. This is like, I don't know, this is kind of like a tattletale response, which is sort of disingenuous and ridiculous. Even though she wasn't at the meeting, she's the one who started emailing me. In a progressive series of self-serving emails, Attorney Little filed the instant motion, including her own emails. It's kindergarten. Lotzi's mom, yeah, it's kindergarten. Aside from its complaint, the defense provides little detail and claimed entitlement for forensically sound copy, in quotes, metadata, in quotes, and logs, in quotes. Not only are these, quote, demands outside the agreement of the parties, the request ignores the facts that the database is not an NVR or DVR, in parens. The unit is a separate hard drive that files were simply clicked and dragged into by the detective who produced video in this case. Well, retired detective DGM Pietro is the retired detective. And where is his affidavit? Thank you, Bentley. Well, no, it's not there. We're just going to say things in our response and not prove them because we're the Commonwealth and that's what we do. Right, that's what it is. DGM Pietro, says Beth. Where's his affidavit? Schmaffidavit. I just want to read that again. The defense provides little detail and claimed entitlement for a forensically sound copy, in quotes, as if such a thing is a misnomer and or a fallacy. Doesn't exist in the real world. What is that? I have no idea. He's saying metadata and logs. I'm sorry, what? Never heard of those things? You don't think they're relevant? You don't think they're claimed entitlement? They are making some sort of false claim that they should be entitled to metadata, logs, and a forensically sound copy? Are we really in the Twilight Zone? Because I think we really have entered it. This is it. If you had any doubt, this is it. Why isn't the prosecution deposed this retired detective? Well, there's no depositions, but why didn't they submit an affidavit from him, a toddler with a law degree? I mean, he doesn't think that they're entitled to it because they didn't keep that video on the NVR or DVR, which we've talked about several times. Hold on, I'm parched. This retired detective simply clicked and dragged it onto a hard drive, didn't save it on the original system. The original system, the system that is used in Canton PD, Sallyport video, is called ExacQ-Vision, EXACQ-Vision. A very nice viewer wrote me a very nice email, and I commented on the video, and I said, please reach out to me because I'm curious about this. And this viewer told me that they work in Massachusetts for a public agency that uses the exact same system, and that there is a way to put a legal hold on video on that system so that it will not be overwritten in 30 days, and that is the proper procedure for doing so, so that it is preserved in its original form. And if you think that Colleen Crawford and the Commonwealth didn't know that, I got a bridge in Brooklyn that I'd like to sell you. But no, they didn't do that. Some guy who's now retired just, put it on a hard drive, and we don't have any metadata, we don't have any logs, and we shouldn't have to give it to you. It's insane. And then he goes on to say, and this is the frosting on the cupcake here, the video stored on the detective file has not been inventoried or reviewed by the prosecutor to date. The Commonwealth intends on meeting its obligations by making a copy of any such video and providing it to the defense. I'm sorry, what? So you drafted this response without even looking at the video on this retired detective's hard drive, which is somewhere where? In a storage unit? Is it at Canton PD? Did he take it home when he retired? What are we doing here? We shouldn't have to give it to you. In fact, I haven't even inventoried or looked at it. Neither has anybody. And he says by the prosecutor. He doesn't say by me. He says by the prosecutor. So nobody's you had the murder weapon. What you're claiming is the murder weapon, Karen Reed's Lexus, in your possession since January 29th of 2022. And not only did you not preserve the video, but there may be video out there that you've never turned over and you don't even know. How can this opposition be made in, good faith is one thing, but without anybody just busting out laughing reading this my mind is blown by this. You're taking the time to respond to this, but you haven't looked at the video or inventoried it. And so is this plausible deniability in case you all of a sudden turn over some other video from the Canton Sallyport? You have had that car in your possession since January 29th of 2022. And all the defense is asking for is the 24-hour period since it came into your possession, I think. I don't remember exactly the time frame, but I think it was only 24 hours. What? And then you're mad about it because Liza Little was the one emailing you and she wasn't at your little meeting. Here's the little meeting. Let's XOXO for the Commonwealth, Michael Morrissey, District Attorney, and that was submitted on February 17th. But remember, I think the hearing was the 18th, right? Let me just go back to my calendar. The hearing was the 18th. And so while it had been docketed, it wasn't scanned in, so we didn't have this before the hearing, but this is what his written response was. XOXO. Hank Breenan. Here's his affidavit, but it's from him, not the retired detective. And there is not one that I could find from the retired detective, unless it's just, I don't have a copy of it. If you know any differently, let me know. And here's what he says. It says affidavit in support, but it doesn't say whose affidavit this is. It doesn't say my name is Hank Breenan. Hold on, we have a little emoji for that. It'll be in the upper right-hand corner of your screen. At a hearing in this case on February 6 of 2025, the court directed the parties to meet and attempt to reach an agreement about the production of unspecified surveillance videos that may be stored on a hard drive at the Canton Police Department and its detective file. I don't think it's unspecified. I think it's all videos relating to Karen Reed's Lexus, the murder weapon that was in your possession, from any and all cameras. I don't know how that's unspecified, but all right, moving on. After that February 6th hearing, Special ADA Attorney Hank Brennan, ADA Laura McLaughlin, ADA Adam Lally, ADA Caleb Schillinger, and a paralegal for the Commonwealth met with Attorney Jackson and Attorney Yannetti in the small room at the back of courtroom 25. Attorney Little was not at court that day and did not participate in the parties' meeting. Yeah, because she was back in LA, kicking off her stilettos and getting to work on all of the ridiculous ducking motions that needed to be filed as a result of that hearing. And her motions were filed, so, there's that. All parties agreed at that time that the Commonwealth would have a member of the prosecution team copy any surveillance video footage in the detective file, store the materials on a hard drive, and then produce a copy to the defense. The parties further agreed that the Commonwealth would videotape the process and provide a copy of the videotape to the defense. Moreover, the defense specifically declined to attend or participate in the process. Nanny poo-poo. Signed under the pains and penalties of perjury, Hank Brennan, Laura McLaughlin, Adam Lally, and Caleb Schillinger. But whose affidavit is this? We have no idea. We have no idea because it doesn't say. Hank Breenan, being duly sworn, deposes and says the following. No, doesn't even say my name is Hank Breenan. We don't know. It's facially insufficient. Will the court care? I don't know. This is docket number 507, attached to docket number 506, and welcome to the Michigas. That is Norfolk County. Forensically sound, what's that? Back to the chat. Kid Crazy says, what strategy could he have not to watch the trial? I don't know, strategy or incompetence. Plausible deniability, I have no idea. I don't think it's a strategy. I just think it's negligence. He says he did read the transcripts now, so who knows? Who knows what's true, what's not, what's right, what's wrong, what's upside down, what's inside out? We don't know. Am I right side up or upside down, as Dave Matthews likes to say? Hey, Jaceville, third motion's coming in again with another 5. Could Judge Canoni be choosing not to rule from the bench because she needs to get approval from someone, Marcy? Anything is possible, but, she has wide judicial discretion and maybe she needs to think about it. Sometimes she rules from the bench, very rarely. Mostly she doesn't. FBI, public corruption, thanks for the 10. Any correlation with Bev pushing so hard for the April 1st trial and the current investigations and revelations coming to light in the last year? Boozy Babe, hilarious and accurate. Yes, she is. Boozy Beauty, I believe her name is right. I believe they have 1 year to retry her from the day the mistrial was filed or declared, which is July 1st. Could she waive that? Maybe. But the April 1st date builds in like a 30-day buffer. They love buffer zones up there. Sal224 became a new member. Thank you. Welcome. Kyle, when I think about what they're doing, when I think about the way they're doing, having to be so precise and careful when pulling files and data, when I was with Dallas, I am nauseated. Yeah. Yeah. So, there's a way to preserve that on the system so it's not overwritten, so that it's in its original, authentic form, so that there's actual metadata and it's not inverted and there's no timestamps that are inverted or skipping or ghosts appearing in and out of videos and timestamps being a different color and moving around and ghosts. Just ghosts. Thanks, Kyle. Bant 1, will Breenan's missteps, lies, and misinformation be accountable, or will Bev put it in the round file, circular file? We'll see. See what happens on Tuesday. What's the over-under? Anybody taking bets? Anybody taking that action? Kyle, the metadata database. The meta database is separate from the files. The logs are persistent and never go away unless manually deleted. Thank you, Kyle. Even if the files themselves are gone. Are you talking about this exact ExecuVision hardware, software, whatever it is? Right. But didn't the expert go into the system and say he couldn't find them, so they must have been manually deleted? Or he was told they didn't exist? Great point. Thanks, Kyle. Maybe you need to be an expert. Alaskan Outdoorsman became a member. Welcome, welcome. Mo, emailed you the link and timestamp to Video Jesus showing Lally's. I don't play other people's content. Thank you, though. But I don't play anybody else's content without their express permission, so I would not do that. But I thank you for the 5. I thank you for emailing it to me, but I don't stream swipe other people. And I appreciate when people ask my permission to play my stuff, and it doesn't always happen, but that's what I do. Showing Lally's D drive files on the screen when he was presenting the inverted video. The files are there. Okay. Thank you so much for emailing that to me. I'll take a look when I have a chance. Inexplicable Susan, thanks for the 10. Video Jesus showed a screenshot from Lally's computer during trial, which had a file named Sallyport 229, 12 a.m. to 11:59 p.m. Great. You guys can go look for that on the Young Jerks show, in which Video Jesus appeared, I guess is where it is. Thank you for your 10. I appreciate you. Kelly Cal, I hate how Brennan keeps saying he invited the defendant to see the hard drive. Why didn't he go to the police station before having that? We just read in his affidavit. Well, maybe his. We don't know if it's his. We don't know whose it is. 4 people signed it. So who's swearing to it? I have no idea. He seems to be not trying that hard, really not trying. Yeah. He didn't even review what's on that detective's computer. It's not inventoried, and he didn't look at it. How can he even come in good faith into court and make any representations about that stuff when he hasn't even seen it? This is what $75,000 gets you in Norfolk County at $250 an hour. Kyle says, I pulled files that the originals were overwritten many times. When I had to prove my copies, I queried the database and brought those in with me. Write the logs. Thank you, Kyle. Appreciate you so much. Kim, I love Labradors. Thanks for coming in with the 20. And the retired detective just happened to be at Canton PD to overhear Brennan asking about the existence of any saved video footage. Strains credulity. Well done, Kim. Well done. Thank you so much. Free Karen Reed, Fab 5 for the win. Thank you. Melanie is here for us. And there is 5,000 or more watching, so smash the like button. Thank you so much. Thank you, thank you. Thank you for helping us not lose our minds. Worry is a wasted emotion, my friends. It's a wasted emotion. Just got to wait and see. Got to wait and see what happens. And then we'll know. Well, the good dog. Oh, thank you for your compliment. I appreciate you so. I would feel better if the 45 pieces of taillight were not allowed into evidence. It's so shady, but I think impactful on the jury against Karen Reed. We'll see if they make any motions regarding that stuff. Because again, that stuff came into the last trial. There seemed to be no logs about when it was found. And in fact, the jury wanted logs. They wanted the CERT team report. They wanted to know what time the pieces of taillight were found and where they were found. And the judge told them, you have everything you need, because it didn't exist. Thank you so much, Lola, for your super chat. Alaskan Outdoorsman opines with a super chat. Thank you. In my opinion, AntBev deliberately cut things short for the media shock value to make the defense look bad. Been watching you a while. Good content. Thank you. Thank you so very much for appreciating me. And also, yes, because as Hank Brennan so artfully pointed out one day in court, which, by the way, Google this quote and you'll be shocked at who it's attributed to. A lie unchecked becomes the truth. You know what else becomes the truth? A lie that halts a hearing that hangs out there for a week so the media and public can stew on it to determine and break down if what you said was true and accurate and in good faith, because so many videos have been made about it, including Boozy Beauty's excellent timeline, which points out that Mr. Brennan may have been less than truthful. So I guess there's good and bad that comes from that. On both sides, right? People are going to go out, they're going to make videos, they're going to prove that what he said was inaccurate. And yet what he said that may be inaccurate hangs out there for a week because many people are not as invested in this case as many of you are and not as familiar with it. Could it taint the jury pool? Of course. Especially if it's incorrect, right? Thank you. So the damage may have already been done. Mike, thank you for your 20. Most informative commentary on this case. Thank you. Oh, thank you, Mike. Mike Nichols. Mike Nichols, aren't you a movie producer? Great name. Thank you for your 20. I appreciate you so. Kelly Jane, I'm 1 hour behind. Didn't the expert who couldn't do anything cost $11,000? Yep, over $12,000. Yes, that motion was denied. $24,000 for 2 people seems likely the same. Brennan, hashtag Brennan drama. We don't even know if that invoice was paid. We don't have a date. We don't know if it was for travel, hotels, lodging. They may not have been paid for their testimony, but they may have been reimbursed for their travel. I don't know. We don't know. But you're right. But he also rendered a report, I think, included with that $11,000 or $12,000. So I don't know. But they had to come twice. Wolf and Rentler had to come twice. They had to come for voir dire, and then they had to come for testimony. Retired Detective File is here. Oh, well done on the name change. This whole case is knucking futs. Well done. Or ducking nuts. Thanks for your super chat, Sal224. Could you explain how the judge could lose judicial immunity and how that would affect this case? Aussie Insider did a great video on it. I have not had a chance to watch it in its entirety. She also did send me a detailed email with all of her research. And when I have time, I may be able to research it further and look into it. I have not even had a time to watch her entire video, but I do know that she does her research. And so thank you so very much for that. I suggest everyone go over to Aussie Insider and look for that video, watch it. If I ever have an opportunity to deep dive into the case law on that, I will, and we can talk about it. But it's so hard to just keep up on the day-to-day filings of this case that it would take hours and hours and hours of time that I just don't have to do that. So I can't promise anything, but thank you so much. Sal for your super chat. Lola the good dog, thanks for the 5. When retired detective was first reference, I thought it could be Brian Albert, LOL. Hashtag insanity, well done. Oh, Andrea, I'm so glad to hear that your husband is getting better. Prayers up for Andrea's husband. Had a medical condition incident. Thank you so much, appreciate you. Lotsie's mom became a new member, thank you. Nikki, thanks for the 10. If Brennan thought those emails were from Tui, they would have been under the federal protective order and couldn't have read them in open court. He must have known they were from the defense. Yeah, I think he misspoke, except for that he made his whole monologue leading up to it was all about how the defense has not been turning stuff over. They've been deceitful. They've been, I mean, not in those exact words. I don't remember his exact words because, it was days ago already, but he did know they were from the defense and he had to correct himself. And as a point, the feds wouldn't have emails between Alan Jackson and Daniel Wolf. They just wouldn't have them in their files. So the whole thing was crazy. And he had to correct himself. Thanks, Nikki. San Fran, thanks to the 5. Hank admitted there's no chain of custody documentation for any evidence and no proof the videos are not edited. How is any of this admissible? I think we've talked about that a couple times. I'm behind on super chats, but just stay tuned for the motions in limine, the motion to dismiss, all of these other things. And Let me just take a look at the upcoming hearing dates because we will be here Tuesday at 11. Who knows how long? We thought the last hearing was going to be most of the day. So that's Tuesday the 25th. And then we have 2 days that are held for evidentiary hearings, March 4th and 5th, which is the following Tuesday, Wednesday. There's supposed to be a final pretrial hearing on March 7th. I mean, we have a lot of dates coming up. There's supposed to be motions in limine on March 18th and 19th. But again, these dates are subject to change based on what happens with the federal appeal and based on what happens with whatever happens at this hearing on Tuesday. Stay tuned, San Fran. Stay tuned. Scott McGinnis is here. Good morning. Karen Reed is fighting the Commonwealth for her life. Good versus evil. Yeah, it's a real David versus Goliath story, right? It really is. Dennis the Menace, thanks for your Canadian 5. Bev knows she is screwed. She wasn't irate. She was shaking because she realized she ducked up. Thank you for sharing your thoughts, Dennis. Fairy Raven. Emma is here. Happy birthday to Karen today. Somebody pointed out in the chat, I think her birthday is the 26th. I only remember because mine is 2 days later. Well, yours might be, I don't know. I think it's the 26th. I heard somebody in chat say, but thank you, Fairy Raven, Emma. We can come back on the 26th and tell Karen happy birthday again if that's when her birthday is. I really don't know. Thank you, Emma. And also for tuning in from Ireland, Sláinte. Lori Joyce, thanks for the 5. Can Hank be held accountable for his misrepresentation of the defense in ARCA? Yes. Oh, yes, he can. How that will happen will remain to be seen. Carrie Watson, thanks for the 5. I think if Bev was going to kick AJ off the team, she would insist he be there in person to do to his face. She'd get no joy over Sam. Well, you know, she's probably not going to rule from the bench anyway. So there's that. Thank you for your super chat, Carrie. Appreciate you. Lola says, shush, don't tell, but I'm starting to miss Lally. A lot of people have said that, and that is very amusing. All right, let's take a look at the motion for sanctions because we have not had a chance to look at that. And also, I think they did not even argue that in court, right? Get rid of the name tag. Karen was not born in 1959. No, she definitely was not. She's only in her 40s. So let's straighten up that rumor. All right. Let us move on to what should we look at next? Oh no, let's look at their opposition to the Crosby motion. Let's look at that. Hold, please. Talk amongst yourselves for a moment. Talk amongst yourselves. All right, this is the Commonwealth's opposition to the defense motion to exclude Crosby. And remember, Dr. Russell had that fiery affidavit that was attached to it. And that was awesome. Let's see what Mr. Brennan has to say about James Crosby and why he should be allowed to testify as an expert in the re-persecution of Karen Reed, even though the judge said during the last trial, nobody who is not a medical doctor is allowed to testify regarding the cause of injuries. Nobody. And therefore she wouldn't let, I think it was Dr. Rensselaer who was going to opine about the injuries not being caused by a car accident. And she said, absolutely not. And so there's that. Okay, let's take a look. Here's the Commonwealth's opposition. on why they feel that they should be entitled to call James Crosby as their expert. All right. Now comes the Commonwealth and respectfully requests this honorable court to reject the defendant's motion without a hearing. This should be good. It is good, I know, because I've already redlined it. Qualifications. Dr. Crosby is qualified to testify as an expert in dog bite wounds. Period. Dr. Crosby's experience teaching, writing, and employment in this area is extensive. Dr. Crosby taught the Florida Animal Control Certification curriculum, served as director for Canine Encounters for the National Law Enforcement Center on Animal Abuse, and has developed a nationwide curriculum for police and law enforcement regarding the proper use of force in canine encounters. Anybody point out to me there where that has anything to do with identifying dog bite wounds on humans as a medical doctor? Must be escaping me. Dr. Crosby earned a Master of Science in Veterinary Medical Science. His master thesis, quote, "The specific use of evidence in the investigation of fatal dog attacks has been peer-reviewed." Wink, nod, say no more, say no more. He also earned a PhD in Veterinary Medical Science from the College of Veterinary Medicine at the University of Florida. Remember, Dr. Russell in her affidavit says, "I don't know what those degrees are. I've never heard of them." You come for Dr. Russell, she's going to attack back like a pit bull. I'm calling her the matron saint of the Karen Reed trial because that affidavit was full of snark and I was here for every word of it. He has received an appointment as a research associate in the Canine Brain Project being conducted within the Department of Human Evolutionary Biology at Harvard University. Well, it only got to the second paragraph to mention Harvard. You ever meet anybody who went to Harvard and notice how they are able to work it into like the first 5 minutes of the conversation? When I was at Harvard. Oh, I remember that from my time in Cambridge when I was in college. Harvard always comes into the conversation somehow. And here it didn't take long, but it has to do with the Canine Brain Project. He's a research associate. Okay. Still not sure how that qualifies him as a medical doctor to opine as to the cause of injuries, but you know. Dr. Crosby has been accepted and testified as an expert in numerous courts, including local, state, and federal courts for both the prosecution and the defense. Footnote 1. Dr. Russell, on the other hand, has never testified as an expert witness in court relative to dog bite wounds prior to the case of Commonwealth v. Reed. Okay, but you didn't point out on what subject he was qualified as an expert in. So there's that. Vicious propensities of pit bulls and the death and mutilation of a person. Canine behavior, canine encounters. Why pit bulls may or may not be dangerous. Rottweilers, other breeds that are known to maybe have vicious propensities and how they could be related to a fatality. Nobody's claiming that John O'Keefe was killed by a dog or the wounds inflicted by a dog. And I don't think that the defense has even ever accused Chloe specifically of causing what they feel to be dog bites. I don't think Dr. Russell has ever testified about her opinions have anything to do with specifically Chloe. And again, Chloe was a German Shepherd, justice for pit bulls. Somebody said in the chat. Methodology. Dr. Crosby engaged in recognized methodology to study the abrasions on John O'Keefe's arm. Dr. Crosby assessed each abrasion individually and collectively. His observations, analysis, and conclusions are clearly stated in his report. His opinions are factually based and are interpreted utilizing his specific training and experience relative to dog bite wounds. Moreover, Dr. Crosby considered supporting evidence or absence of, including DNA analysis. Oh, hold on, we need to break for that. Well, he couldn't have analyzed any DNA on the swabs of the wounds to John O'Keefe's arms because no swabs of the wounds were taken. Dr. Crosby also examined the canine alleged by the defense to have inflicted the abrasions. And maybe I am missing it, but did the defense ever say that it was specifically Chloe? Or that's just reasonable doubt that Chloe was rehomed? Let me know. Oh, Sally Poltergeist is here with a new name update. What do we think? Loving it. I'm loving it, Sally. Sally Poltergeist, well done. Well done. Q. Garrett Wing. Kimberly says they have never alleged that it was Chloe. Scott says, all that remains in question are the cuts and scratches on Officer John O'Keefe's arm caused by a dog, which requires Dr. Russell. This dog behavioral expert carries no weight. I agree with you, Scott McGinnis. I agree. Nope. Pure Duckery. Nope. Grass Folk never said it was Chloe. Dr. Crosby also conducted a dental examination, including photographs and actual measurements of Chloe's jaw, teeth, and claws. The methodology employed was based on facts, science, and study. See Defense Exhibit 1, which I guess is a copy of his report, which is not sworn to. It's not an affidavit, it's a report. Pointed that out when the motion was made. The methodology makes clear the abrasions on John O'Keefe's arms were not caused by a, quote, dog attack or by Chloe. Footnote 2. Dr. Russell's opinion was that she was unable to identify the cause of each abrasion separately, but could somehow opine collectively that the wounds equaled a, quote, dog attack. Well, yeah, somehow? Oh, you mean based on the hundreds of dog bite patients that she had treated throughout her decades-long career, something like 30, 40 years, and also treating prisoners who were brought down by police canines and the wounds inflicted therefrom? Somehow she could opine that? Okay. Curiously, Dr. Russell's affidavit accuses that Dr. Crosby's report is defective because he, quote, does not footnote any source of authority in the text of his report. In parentheses, it says, despite pages of authority cited. We haven't seen the report, and so I don't know about the footnotes, but I think she said he just listed a whole bunch of publications and says, these are things I may have relied upon, but doesn't point to specifically where. The comparison is interesting given that Dr. Russell's entire testimony and opinions lacked adequate authority. It's nothing like, real world experience and medical experience, but they lacked any authority other than all those peer-reviewed articles that you brought up that she actually relied on. So there's that. Notice, Dr. Crosby has provided a full report, including his training, experience, writings, methodology, opinions, basis for opinions, and examination data. All this discovery has been provided to the defense before his potential rebuttal testimony at trial. Well, now for the first time we are learning that they don't even know if they're going to call him, but if they do call him, he's only going to be a potential rebuttal witness at trial. So they don't intend on calling him in their case in chief. They don't intend to head off dog bites at the pass. They intend to use him as a rebuttal witness to Dr. Russell. Okay, well, they're not even on the same level, so good luck with that. Dr. Russell's introduction to this case is a marked contrast. Listen to this, ready? If you haven't been listening, listen up. Dr. Russell parachuted into this case mid-trial with no notice, no report, and no identified opinions. She parachuted in. I kind of like it. She parachuted in. Her opinions about abrasions routinely changed and varied significantly between her voir dire trial testimony and her testimony at the Lanigan hearing. The defense only provided a report from Dr. Russell on the eve of the Lanigan hearing. Dr. Russell's report still lacked methodology and clear conclusions. The defense is clearly on notice of Dr. Crosby's qualifications, methodology, expertise, opinions, and basis for his opinions. Well, some of you may recall that Dr. Russell was brought in for 2 full days of voir dire. I've never seen a voir dire of an expert go that long in my career, and many other attorneys have not either. And so you had the ability to cross-examine her on just about everything, which you really did. Try to, denigrate her, and she wasn't having any of it, but you tried, and the judge ruled against you, and Dr. Russell is going to testify at this trial, like it or not. For all these reasons, the court should allow the Commonwealth to potentially call Dr. Crosby as a rebuttal witness. XOXO, Hank Brennan, Adam Lally, Laura McLaughlin. And then they do attach an affidavit to this one, and there it is. This one is actually by Hank Brennan because it says in the first paragraph, "My name is Hank Brennan, and I am special counsel assigned to prosecute Karen Reed." I reviewed the motion of the defendant to exclude the testimony of the Commonwealth's witness, James Crosby, along with the attached exhibits, docket number 499. I reviewed Dr. Marie Russell's voir dire testimony, trial testimony, and Lanigan hearing testimony. Well, he did his homework on this one because they really, really, really do not want Dr. Marie Russell to come in and talk about the injuries to John O'Keefe's right arm being dog bites. They don't want it. So that's where he's focusing his time. Some of it, anyway, at $2.50 an hour. I have reviewed Dr. Marie Russell's affidavit. I reviewed Dr. Crosby's report and disclosures. I reviewed the court's memorandum and order relative to the testimony of Dr. Marie Russell. Dr. Crosby presents as qualified, experienced, and engaged in substantial methodology outlined in his report that has been provided to the defense. And Dr. Crosby reports that he has been qualified and testified in court dozens of times, including local courts, state superior courts, and federal courts. XOXO, signed under the pains and penalties of perjury, Hank Brennan, dated February 17th. And so there's that. My opinion is she's going to have to order a Daubert hearing on Crosby because Hank Brennan doesn't even say what subject matter he was qualified in to testify in other courts. And so he's also not a medical doctor. She will absolutely not deny this defense motion on the papers. In the real world, it shouldn't happen that way. There should be a Daubert hearing, and or she should grant the defense motion to exclude Crosby on the papers because he's not a medical doctor and therefore is not qualified to opine on the cause of injuries to a human based on her own monologue during the last voir dire and or trial that was pointed out and quoted directly in the defense's motion papers. Right? Am I right? Back to the chat. Jerry is back from Canada with another super chat. Says there's no evidence of truth. There is Turtle Boy haters, and I believe there will be McCabe and Albert haters soon. Someone will talk. Look, I've said it before. I'm going to say it again. I said it yesterday. And both things can be true. We can feel sympathy for Aaron O'Keefe. For those of you who don't know, and I'm not getting into the side drama of it right now, but Turtle Boy broke a story the other day. He's got receipts from a woman who was allegedly having some sort of on-line relationship with Paul O'Keefe. He told her lots of things. that are not good for him, that if I was his wife, I would be livid about. I feel sorry for Aaron. I feel sorry for him, for her, and both things can be true. You cannot like Aaron and you can feel sorry for her at the same time, and for his children if all this stuff turns out to be true. Something was said in the article or between text messages that they really need Aaron's testimony at this trial. Aaron's testimony, in my opinion, we talked about it. She testified day one of trial. I thought it was good for Karen. I thought she missed Karen. I thought they had been good friends. I thought that they were both in relationships with, they were in relationships with brothers who were drinkers. And I think somebody pointed out that probably was a bonding thing for them. If you've ever been involved in a relationship with somebody who drinks a lot or is an alcoholic, maybe you can relate. You can feel bad for Aaron and also think somebody pointed out that she yelled at Mr. Reed one day in court. I don't know. I haven't seen that on video. I don't know. Could this be the straw that breaks the camel's back? I don't know. But I have sympathy for her. And that just reminded me of that. Jessica Whaley, thanks for the 5. Rob and Runkle thought there was a good chance Brennan knew the defense sent the discovery from the beginning. Your thoughts? And that he intentionally misstated that in court? I don't know. Jessica, were you the one who sent me that stream, or said somebody sent me an email and said, you have to watch the Runkle and Rob Lawn Lumber stream? And it was like 5 hours and 47 minutes. And I don't have time. But I'm sure that he knew. He had to have known. So was it intentional? They're saying what he said in court was intentional and made to muddy the waters. I can't really talk about their opinions because I'm not fully familiar with their opinions, so I don't know. He knew damn well who sent it to him, because I'm sure there was a cover letter with it. It just didn't come with like a document dump. I'm sure it was like, attached here too, please find the following. He absolutely knew. But again, I don't know what they said, so I can't really comment on it. Did they say he was intentionally trying to mislead the court, Brennan? Because Brennan is accusing Alan Jackson of doing just that. But really it was David Yannetti who spoke in open court. So I'm confused about the whole thing. I think we should just wait until Tuesday and see what happens. Thank you, Jessica, for your super chat. I appreciate you so much. San Fran says, P.S. Love your earrings. Thank you. Thank you very much. These are Fire Dancer earrings from Dave Matthews, Cancun. Thank you. Appreciate you. Grace Base just emailed you a link to articles on Dr. Crosby. Thank you very much. I am not going to stop the stream and pull them up right now, but I will take a look at them when I have the chance. If I tried to go over everything that you guys are emailing me during the stream, we'd be here for days. And I love you so much, and you're so collaborative. And I do read all of your emails. I just can't respond to all of them. And I just can't address every single thing that you want me to address on TV. I mean, on the channel, because a lot of it I can't verify, but I appreciate all of your input. And if you guys want to go and dig into that, you guys are no better armchair detectives than all of you guys. It just did. Thanks for the 5. If, God forbid, AJ gets kicked off the case, I feel okay with Mr. Alessi stepping up. I don't think that's going to happen. I don't think there are grounds for it. I think we need to wait and see what happens on Tuesday. I think that Alan is very well prepared with whatever he's going to say when he comes in. And let's just see. But that's that's a nice thought that you feel good about it. GV, thanks. Dr. Russell affidavit is career-ending diss track. Yeah, it was great, right? So good. So good. So good. Okay, let's look at the latest discovery drop by the Commonwealth. Let's all hit the like button because, helps the girl out, helps the algorithm, helps other people find us, and gets the word out about what we want to say. There's 5,000 watching. We have about 2,500 likes. That's about 50%, but I think we can do better. I know we can do better. So you might have to close out the chat to smash the like, but I know you guys can do it because you're amazing. You're amazing. Let's take a look at that latest discovery dropping. See if we can figure out what it is, because sometimes we can figure it out, sometimes we can't. Let's see where it is. It was, I think, 512. Docket number 512, 512. So remember, Commonwealth was supposed to be finished turning over discovery because they filed their certificate of compliance, but no. This is stamped February 20th, which was, today's Saturday, so this was filed Thursday with the court and is entitled Commonwealth's Notice of Discovery 59. That's how big we are into numbers. We're that big into the numbers. Number 59. More papers. God save the Commonwealth. Now comes the Commonwealth in the above captioned matter, and it indicates that as of this date, the following discovery and materials have been provided to the defendant through defense counsel. 1. Copy of production Rule 14 materials from the Norfolk District Attorney's Office, which was previously provided by email on February 6th of 2024, subject to a protective order filed on January 31st. So I'm not sure exactly what that is, but they turned it over on February 6th. I don't know. Thoughts? Anybody know what that is? Number 2, copy of law enforcement sustained findings. That is probably something to do with one of the internal affairs investigations. There were a couple of investigations. Number 3, copy of the transcript of Commonwealth versus Aiden Carney, December 17th of 2024, 32 pages, including the word index. Did he refer to that the other day when he was arguing why Mark Betterow, maybe the court should not admit him pro hoc vice? Could be Marcy emails, could be some things that they've already turned over. Huh. Number 4, copy of raw data images and scans from Aperture provided in hand on February 18th. I know what that was. That was the measurements that were taken of the driveway and the Traverse and the Lexus. And so I think based on those measurements that were given, they said they don't need to go to One Meadows driveway and look at the cars, that the measurements would be enough, right? Yes, he quoted Bradel. Thank you, Emmy. Thank you for that. Bradel is one of Aiden's attorneys. The other one is Mark Betterow. Thank you, Suze. 1217 was motion hearings, phones, texts, etc. That was what they were talking about in Aiden's hearing. Okay, good. So again, here they are, still turning stuff over. Oh, Bradel talking about the joint defense. Okay, right. And she said she wanted that transcript, right? Did she say that? Let's see. This was filed on the 20th or the 19th, and the hearing was the 18th. Maybe she said, "Give me these things before the end of the day," right? Green-eyed Southern girl. He says he's concerned about the close relationship between Aiden and Mr. Betterow and Karen. Right. And I think he asked, maybe that's his proof of that. But those exhibits are locked down, so we can't get a hold of it. Let's take a look at the motion for sanctions, because he does talk about the reason that he wants sanctions, and we were wondering about that. And that is another motion they didn't get to argue the other day on the 18th. So let's take a look. Where is that? Here's the Commonwealth motion for sanctions. It's only 3 pages. This is docket number 504, docket number 504. It's good that we get to do all this housekeeping today because we needed to catch up. And so here we are catching up. Lola, thank you for the 5, says Dr. Russell parachuting into court too. I came in like a wrecking ball is my happy place. I love it. Hashtag respect, hashtag a real doctor. Oh, thank you, Lola. That's good. Excellent. Well done. All right, this is docket number 504. This was filed. It is stamped on February 14th. Happy Valentine's Day. Commonwealth's motion to impose sanctions pursuant to Rule 48. Hold on. Now, now comes the Commonwealth and requests that this honorable court impose sanctions against the defense for their repeated and willful violations of court rules and protective orders. Under Massachusetts Rule of Criminal Procedure 48, willful violations by counsel and violations of court orders shall subject counsel to such sanctions as the court shall deem appropriate, including citation for contempt or the imposition of costs or a fine. The purpose of this rule is to regulate the conduct of attorneys who practice therein, the courts of the Commonwealth, and to discipline those whose actions fall short of accepted standards. And that is contained within the reporter's notes of Massachusetts Rule of Criminal Procedure number 48. Ambling Soul says willful violation. Sounds like a hammer needs to come down on the Commonwealth. I know, and it's funny that this is their motion, right? Green Eyed Southern Girl says Mr. Betterow fell free fallen. He was free fallen into the courtroom. He didn't even use a parachute. Didn't even use a parachute. So there's that. I don't know. Somebody says, anybody else having trouble hearing? Are you guys having trouble hearing? Can you hear me okay? Check. Check 1. Check 2. Check. Check 1. I can turn my volume up maybe a little bit. But I don't know. Anybody says they can hear me fine. Okay, fine. All right. Better Bomb from space. None use your business. One of my favorite usernames of all time. Oh, here's what I was going to tell you. I watched last night. I made the mistake of watching anyway. The Chris Watts documentary on Netflix. Has anybody seen that? That was before my time as a law tuber, and so I did not follow that case closely. I couldn't sleep. Those cases with the kids are so hard. There's a lot of like official body cam video footage and interrogation footage in it. I don't know when it came out, but we watched it last night and I couldn't sleep. It was terrible. I had to watch comedy afterwards to get my mind off of it. So I didn't like it at all. Did not like it at all. Not that it wasn't done well. The whole thing about that case is just so disturbing. Yes, so disturbing. Yeah, that was my intro. Yes, that was my intro. Yeah. Not a good intro, and I don't like it. Just that was a side note. Okay. Thank you, Emily. Okay, awesome. On February 11th, 2025, in the, quote, defendant's motion to reconsider reciprocal discovery order, it appears that the defense flagrantly violated protective orders previously agreed to by the defendant and set by this court on November 13th, 2024 and January 31, 2025. See docket entries 416 and 468. Hang on a second. I don't know if I have them, but hold please. Hold please. Not easily accessible by number anyway. Okay. In the defendant's motion, it quotes a text message sent by Trooper Michael Proctor. This text message is subject to the protective orders, and the January 31, 2025 order specifically restricts, quote, the public dissemination of all communications, including, 1, those within the work cell phone of Massachusetts State Trooper Michael Proctor. See docket entry 468. The defendant attempts to unilaterally amend the protective orders by claiming that that only the screenshot of Proctor's text message is subject to a protective order. See defense motion, page 9. This is an obvious violation of the protective orders. Further, the defense's claim that the protective orders are limited to personal identifying information is misplaced. Before communications were produced to the defendant, personal identifying information such as phone numbers were redacted. purpose and necessity of the protective orders, as stated, is to effectuate the well-established privacy and safety interests of witnesses and to protect the integrity of ongoing investigations, a recurring issue and concern in this case. And remember, that text message was between Proctor and Lally, and Proctor called Jackson an a-hole and said, I didn't watch that a-hole's closing argument because we're all really worried. We're all really worried about the verdict, or something similar as such like that. Notably, this is not the defense's first violation of a protective order or court rule. The defense has repeatedly displayed autopsy photographs of the victim without permission of the court, and has previously filed motions with photographs and names of juvenile witnesses, photographs of the victim's deceased body, and has released witnesses identifying information to include their names, dates of birth, social security information, addresses, and phone numbers. See Massachusetts Rule of Criminal Procedure 32, F, Supreme Judicial Court Rule 124, and other rules. But then he's not giving any examples of that or citing any examples of that. I know they did hold up an exhibit once in court, because I remember we watched that hearing together. That was a pretrial hearing. He's not citing any examples. Further, this court previously ruled that it is unacceptable for the defense counsel to misrepresent and distort facts in an impounded. Further, this court previously ruled that it is, quote, unacceptable for defense counsel to misrepresent and distort facts in impounded documents and to fail to comply with orders of this court, all of which have happened in this case. The court will not tolerate actions by defense counsel which waste the court's time and resources or violate the rules. See docket entry 262 at page 10. Well, we're on docket entry 514, so that was a really long time ago. And did he attach it to his motion? I don't know. Therefore, the Commonwealth moves that the defense be sanctioned to include, but not limited to, being ordered to file all motions under seal and impounded until such time that both the Commonwealth and court can ensure that the filings comply with all previous orders set by this court. Oh, so you want to be the police of that? So you want the defense to have to impound all of their motions? Hold on a second. All right, first they want sanctions, which can be monetary or otherwise, to include but not limited to being ordered to file all motions under seal and impounded until such time that both the Commonwealth and court can ensure that the filings comply with all previous orders set by this court. They want to play court police? Yes, Kate, great point. Kate says, hold on, I'm behind on the chat, but hold on. Kate says, Hank is trying to keep the motion to dismiss from being public, in my opinion. Oh, is that why we didn't see it at the docket yesterday? Because of this motion that has not yet been ruled on? Yep. He doesn't want that public. He doesn't want all the violations. John Doe says violation of the First Amendment. Yeah, so the Commonwealth can approve it, right? Me, Mary D, yeah. The content of improperly filed motions serves to taint the prospective jury pool. Well, so does your lie hanging out there unchecked for a week, or deliberate misstatement or negligent misstatement of who turned over those emails to you, the feds or the defense. The content of improperly filed motions serves to taint the prospective jury pool. See the rules of professional conduct, 8.4D, engaging in conduct that is prejudicial to the administration of justice. Well, that's pretty broad, isn't it? XOXO, Hank Brennan, dated Valentine's Day. I don't think there's been a ruling on this. I don't think there's been an opposition to this. That's docket number 504. And he doesn't give any specific examples of them disseminating information of witnesses. What did he say? Witnesses? Hold on, let's go back. Photographs and names of juvenile witnesses, photographs of the victim's deceased body, and has released witnesses identifying information, names, dates of birth, social security information, address, and phone numbers. I don't know. Has that been done? Because there's no specific examples cited here, so I don't know. And I don't think that there's a response to it yet. Anybody seen a response? That is another motion that is yet to be heard. So we're going to see what's happening. Thank you, K-Wags, for your 20. It bothers me. People are going after experts' family. My bestie's husband is a rocket scientist, called it as an expert. Once he signs an NDA, he says nothing. Bestie could be in a group. No idea what he's working on. Right. I agree, but the cesspool of Twitter has no rules, I guess. It's and it's happening on both sides. People who hate Karen Read and think she's guilty and should hang in town square, and people who believe that Karen Read did not hit John O'Keefe with her car. It's crazy. I've never seen anything like it, ever. Then again, I've only been on YouTube for a year and a half. So I guess this stuff has been going on for a very, very long time. And I was like naive enough to think that people were, I don't know, classy, had some decorum, would not attack. I don't know. Free Karen Read, Fab 5 for the win. Thanks for the 5. Melanie is here for us, and there are 5,000 or more watching, so smash the like button, please. Thank you for thanking me for helping you not to lose your mind. I appreciate you. Deborah Claire says, you're the one that makes a boring Saturday an awesome day. Thank you so much for your 10, Deborah Claire. Facts matter. Thanks for the 20. Has the judge ever once taken the Commonwealth to task for their discovery violations and antics, or just saves that for the defense? Well, you've been there with me. We've been here for a year, over a year, covering this case, and pretty much I haven't seen so far, if anybody can point out to me differently, that the Commonwealth has faced any ramifications for their behavior of late disclosures and improperly authenticated evidence without foundation or metadata. I haven't seen it. That's funny, Lola. I addressed that earlier. Parachutes and pirouettes. Well done on the name change. My Canadian friend watching from South Alberta, Canada. Kyle says sustained findings. You don't want to hear that for real. Internal Affairs. Thank you, Kyle. Amy's Positive Pathways is here. Discovery ID, Karen Read documentary. I don't understand till things are concluded one way or another. I will still watch it though. Yeah, there's a 2 or 3 part documentary that I heard is coming out in March that Karen must have participated in because they have interviews with her. I don't know a lot about it. Can't really opine or talk about it because I have not researched it. It's been a busy week. Amor Avalesi, Mel, when Nick and Knight had Mary Tyler Moore, I always brain cleaned with her show before bed. My friend says, I need some Mary Tyler Moore in right now. Yep. Mary Tyler Moore is good for that kind of stuff. Yeah, a little decompression, a little palate cleanser, right? Well done. Well done. That's a great idea. We addressed this, K-Wags. Thank you so much. Looking forward to your analysis next week, says BL Blazy. Well, thanks for being here for a month. Pineywood says, I'm such a nerd. I love reviewing legal documents, even as I scream from the sidelines. I know. It's crazy. Thank you so much for the 20. Let me see if there are any other questions before we wrap. Let us see. Yes, so you all should be aware. Thank you to NASDAQ for letting me know that in Norfolk County, the time lag between filing and docketing can be as much as 2 business days. So we're hoping that if the motion to dismiss was filed yesterday, number one, that it won't be impounded based on that motion. And number 2, that we'll be able to get a copy of it on Monday because we may not be able to get it before the hearing. Not that they're going to address it during the hearing anyway. So there is that. Let us move on to Susan Walker for the very, very generous Venmo. Thank you for 50. Says, Thanks for all you do to explain these legal documents. I appreciate you so much. Thank you, thank you, thank you. Cyber Chicken Boston says, yay, I'm catching a live. Thank you for your Venmo. Appreciate you so much. And let us see. Questions, comments, thoughts, concern before we wrap on this 2.5-hour Saturday morning stream. Anything we didn't cover, that we forgot to cover, that we need to cover? Vanessa, thanks for the 10 Commonwealth's motion to impound exhibits in support of the Commonwealth's motion to impose sanctions. That is, they moved to impound exhibit that was a audio voicemail from the Gretchen Voss notes. Hold on. Here's a copy of it. Hold on, let me see if I can pull this up here. Let's just see. The Commonwealth moves. This is docket number. I don't know because there's no number on this one. This was just filed yesterday. But that made the docket strangely or coincidentally or not so coincidentally or whatevs. Motion to impound exhibit in support of Commonwealth's motion to impose sanctions. The Commonwealth moves pursuant to Trial Court Rule 7, Uniform Rules of Impoundment Procedure, that an audio file and associated exhibit page being produced to this court as supplemental support to the Commonwealth's motion to impose sanctions. Okay, so they're supplementing that motion that we just read. Be filed under seal and impounded. So it's an audio file, and I think it's from Gretchen Voss. This audio contains statement of the defendant and defense counsel that were produced to this court pursuant to the Commonwealth's motion, paper number 429. Commonwealth moved that the audio file be impounded and not available to the public, as premature disclosure and dissemination could prejudice the ongoing proceedings. Commonwealth reserves the right to play portions of the audio during court. Oh, so we want to be able to play it in open court, but we don't want it. We don't want anybody else to know about it, but you want the defense to turn over all of their impeachment evidence to you. Do you see how this is? Do you see what's going on here? Do you see what's going on here? And then, of course, Judge Kenobi signed this right away yesterday and said it was allowed. Paper number 429. I'm sure somebody's, let me see if I have easy access to that, but I think that's the Gretchen Voss motion to get her off the record notes or emails. They didn't get her notes, but they got her emails, I think. I mean, voicemails. Is it a voicemail? That's what I think it is. Yeah, the good old double standard trick. You know, shocking and not surprising. Thank you, Vanessa, for your super chat and for reminding me that that was something that actually did hit the docket yesterday. Is it crazy? Yeah. Got to remember that Norfolk County has its own rules. Yep, they do. Feels like it. Where they kind of twist them. So there's that. Let's see. Thoughts, questions, comments, concerns. Let me just scooch through here. Whose social security number did they release? Yeah, right. I know. I'm curious too. Deja vu trial too says, I think they don't want YouTubers to read the motions. I don't know. Maybe. Sanctions for Hank. This isn't the first time he misrepresented to the court, says Green-Eyed Southern Girl. Pineywood says, everything he writes or says is so self-serving. Also, he writes as though it's the Commonwealth and not the court versus Karen Reed. Yeah. I know. I don't know what Uncivil wants or is upset about. Your name appears highlighted to me. What are we talking about? Can't see what. Did you send a super chat? Because it's not in my column. I don't see a super chat in my column from you. Did you send me a super chat? He says, I am not upset. I am happy. Are you happy? Did I not address a super chat, honey? You know I would. You know I would always address your super chat. But I'm in a weird location with weird internet. I had to go get an Ethernet adapter. And so finally today, my stream is working for me. Now I feel like I want to stay here for a couple more weeks. I wish I could. It's sunny out today. Okay, so there's that. Kurt, I don't know if you did a stream on the federal appeal, but if you did, I will direct people to your channel to watch it because Kurt is very, very good with constitutional law and also breaking that stuff down, Supreme Court arguments, things of stuff like that, and to get another opinion and take on things, Lori Hamilton says, and appellate stuff. I appreciate you, Melanie. I'm trying to avoid all the gossip. All I care about is Karen's acquittal. I know. I try and avoid it too. But I just think if somebody is going to flip, maybe. Hell hath no fury, my friends. Hell hath no fury. Like a woman scorned. Oh, he's not upset. Someone asked why he had the great check. Okay, he's got the great check mark because he's got over 100,000 subs. You know, that happened to me the other day too. It may be that your credit card is expired, the one that you have with YouTube, because I think that's what my issue was. Like whatever you have attached to your super chat YouTube thing could be expired or something. I don't know. But thank you. I appreciate you just even thinking about sending me a super chat is so very kind and generous. So there's that. I bid him, thanks to the 5. Why did she sign Judge Cannoni? She usually signs Beverly B. Cannoni. Beverly J. Isn't her name Beverly J? No, on YouTube, if you have a check mark, it means you have over 100,000 subs and you got the silver plaque. And I'm trying to get one too. So let's see if we can get the subscriber count up, because don't you think a silver plaque would look so nice on the wall behind me at my regular location? Thank you so very much. I think so. And we're up to how many? 76.4 thousand. Not bad. Not bad for a year and a half, you guys, but we can do better and it's free. It's free. It is free. Also in a personal competition that Vinny Politan knows nothing about to beat him in subscriber count on his own personal channel. And I do like Vinny. Been following Vinny since, the 90s. And so they'll send us your car instead. Right. It would look great, I agree. We'll get there this year. We'll get there. She's Beverly J. Oh, Haley Mouse, she's BJ Cannoni. Don't run with that, my friends. Don't run with that. But yes. And Sybil says, you gained your 76,000 a lot faster than I did. You're doing fine. Keep up the good work. Thank you. Thank you. And as you know, I don't permit bashing about other creators in my chat. And so this is not the place for that. Not saying that you would bash Kurt, but sometimes people tend to bash other creators, and I don't approve. I don't allow it. Gets deleted. So if you've been deleted or blocked, it may be because you were bashing someone. It may be because you put a word in your chat that is a blocked word. It may be because what you're spreading is misinformation. There could be many reasons why. But if you're sending me emails during the stream, why am I blocked? I'm not going to address that on the air. So my moderators are the best on YouTube. We run a tight ship here. That's why a lot of people come here, because they know that they come here and they're not going to hear trash talk. And they're not going to be able to say whatever they want that is disparaging to other people and defamatory. I just don't allow it. Nina Vanderhoof, thank you, says, so an Amazon driver runs over a woman and she had no life-threatening injuries, but Karen kills John O'Keefe by backing up. Well, backing up and only hitting her arm. Only hitting his arm, which exploded the taillight. It exploded into many teeth-shaped pieces and made linear abrasions on his arm all at the same time before he did the pirouette and was thrown 30 feet into the lawn. I don't know. You also may be unsubbed. YouTube does that sometimes. So you can check and make sure that you are subbed, because sometimes you're not. And then, you might not get the notifications or what else. Hard plastic and static mannequin says, this is just because. What else can you say? Thank you. Thank you for your just because. Adam Handful, because that's very nice. I appreciate you. And you DoorDash some cupcakes. I got a cupcake the other night from Sprinkles and it was worth it. So awesome. Lemon blueberry cupcake. I thought of you guys. All right, we keep it classy here. We try to anyway. This is not an easy case to cover. I do have the best moderators on YouTube. I back them up 100%. And let me just see if I missed anything. Stay cool, stay kind, stay classy. And also, Steve says, just because you bring it. I'm here. I'm here for you. I'm here for you, except for when the internet doesn't work out and StreamYard sucks. And you know what they did? They doubled it. They sold the company, StreamYard. They doubled the pricing. And it just doesn't work the way it should. It's not, and I don't know what the other options are. Not a lot. OBS, I don't know how to use it. I'm not a techie. I want plug and play. I want easy. All right, you guys, you're amazing. So please do the things and stuff that YouTube approves. And okay, here Uncivil says he will do a live when I'm done and break down the federal filing. Awesome. Do it. He's smart, intellectual. He has a kind soul. And I appreciate his intellectual opinion, says Legal Minded Friends Carol, and that's true. That is true. I agree with you 100%. He's always been very, very nice to me. And so there's that. All right, my friends, I'm going to go enjoy some of my vacation. Oh, and look, you found me through Uncivil. That's awesome. Yes. Turboy's thumbnail saying Paul O'Keefe may have testified while intoxicated and may be using these proceedings to pick up chicks, allegedly. There are some screenshots of some text messages which may or may not have been catfished. I don't know. I have no idea. I don't know. I don't really follow it, except to say that if these things are accurate and real, he did apparently maybe say that. He may have been hammered when he testified. Could that be fodder for cross-examination at this trial? Yeah, could be. Impeachment evidence? Yeah, it could be. I'm just saying, there's that. Do all the things and stuff that YouTube likes, my friends. Please feel free to comment respectfully in the comments. Be kind to each other. Stay cool, stay kind, stay classy. And you can do it. I know you can. Rise above. Rise above. Don't go out there bashing other people. Who needs it? We don't need it. There's too much drama in the real world. We don't need it in the fake world that we live in so many hours of every day. Cupcake members, I love you all of my heart. If I don't see you soon, I'm gonna die. I don't know when I'll be back, but that's why you want to have the notifications set to all so that you will not miss a beat. You won't miss a beat. Maybe tomorrow night when we'll see. Peace, my friends, peace. What the world needs now is peace. More of a Leslie is in midair, mind you. Excellent job getting that through. Until we meet again, my friends. Bye.